Good afternoon, everyone. Welcome to the Appellate Division First Department. We have our oral arguments for today, March 3. So please ask for the time that you actually need in order to get out the salient points of your argument. Please keep in mind that we have read your briefs and we are familiar with those arguments. People v. Edward Goldfaden. 4-2 and 4. Anand v. J.B.J. 515. Matter of Marie, that matter is submitted. Castro v. City of New York. 5-2 and 3. Mendes v. Primitive Christian Church. 525. Levy Chin. 5 and, I'm sorry. You said 5 and? Thank you. 5-2 and 4. People v. Michael Jones. 525. Galaza v. City of New York. 525. Trump v. Trump. Excuse me. 525. Matter of Victoria. Excuse me, that matter is submitted. Light and Wonder v. Mohawk, that matter is adjourned. Escudero v. Belmont Avenue. We do not have an appellant. Did you wish to submit or did you still wish to argue? Submit, thank you. Canara Bank v. MVP Group. He said 10 and 2. 525. People v. Jawan Thomas. That matter is submitted. Shuford v. the City of New York. I understand that the respondent is not going to be here. Did you still wish to argue? 3 minutes. Reynolds v. Ford O'Brien, LLP. 535. People v. Taquan Wilson. 524. Robinson v. Red Leaf Capital. That matter is submitted. First case for argument is People v. Edward Goldfaden. Yes.
Good afternoon, Your Honors.
How are you? I haven't seen you in a while.
It's been a while, yes, Your Honor. Good to see you, too. My name is Mark Zeno, and I represent Appellant Edward Goldfaden. May it please the Court. Court below erred when it refused to submit trespass as a lesser-included offense of the Picart residential burglary.
Just that one? Just that residence?
Well, I think the issue is much clearer with respect to the residence as opposed to the 118 kitchen. I believe that the court erred in both instances, but the residential burglary is the offense for which my client is serving a 16-to-life sentence.
That's the one where it is alleged that he took the Metro cards.
Metro cards, correct, Your Honor.
Wasn't he also, he was seen in the apartment by the apartment occupant, by Ms. Picard?
Right, in the home. He had entered the home. Unclear. It's clear that I believe that, and uncontested, that the doors were unlocked. He entered. The question is, did he enter with the specific intent to commit a crime?
Well, if something is missing and he's there and obviously nobody invited him in, wouldn't that constitute a burglary?
Well, two answers. If he had the intent to take something when he entered, as opposed to it being a crime of opportunity, we've alleged...
As opposed to it being?
As opposed to entering...
Oh, I'm here, so I might as well take something. Oh, I'm here. Oh, it looks good. Let me take that.
Entering to get out of the cold on a February day and taking the Metro
But he's well covered.
He had a coat.
He had a coat, so why enter someone else's place?
Living in a
when
shelter.
There are many places you can go to.
living in a
Did he
shelter.
ever say that he was going to keep warm? Did he ever
He
make
did
that
not
statement?
testify, Your Honor. So no, he did not say he was entering.
What about the 440 issue?
The 440 issue, the Erlinger issue?
Yes.
Sure, I'm happy to address that. The court denied the Erlinger motion purely on retroactivity grounds, did not address the merits of the claim. Therefore, this court is only empowered under LaFontaine to consider that ruling. Since my client's conviction wasn't final at the time that the motion was brought, it applied fully to his case.
So do we need a ruling? Should we send it back so that the court should make a determination?
That's the correct remedy here, Your Honor. I don't think the court can do anything else. It can't make an advisory ruling. It just needs to send it back because the basis, which I don't believe the people contest, the retroactivity basis was misplaced. They make some arguments that it actually reached the merits of the claim, but that's not supported.
Well, I think the people have they had an alternative theory, right, in terms of affirmance?
Well, they have a number of alternative theories. They have waiver, harmless error, but again, the court did not reach those below, so this court can't reach them on appeal.
Thank you.
Thanks.
Good afternoon. May it please the court, Jennifer Westfall for the people.
So to pick up on that last point, since the court did not make a determination as to the 440, how can we make any type of determination?
We submit that this court is certainly free to reach that issue on the harmless error aspect. After all, intermediate appellate courts routinely affirm based on harmless error analysis.
But the court did not reach a determination.
Right. The problem is there's nothing to analyze. We can't analyze anything to make a determination whether it's harmless or not because it never made a determination.
But we also maintain that though the judge could have been clearer, that taken together the judge's factual findings and legal conclusions amount to a determination that defendant had waived his right to bring this challenge because he had admitted the incarceration periods alleged in the predicate felony statement.
Did the court say that?
At the beginning of his oral decision, he noted the people had raised that argument, and he had found that defendant indeed did not dispute any of the charges in the statement. And then in declining to find CPL 415 and 416 unconstitutional, the judge concluded that when a defendant admits to the contents of the statement, a defendant obviates the need for the court to make such a factual finding in violation of Erlinger. So we submit that together, while the judge could have been clearer, his factual findings and legal conclusions.
So did the judge actually state that that was the basis for his decision?
Not explicitly, Your Honor. Unless there are no further questions.
Did you wish to address the trespass issue at all?
Just briefly, we submit that the request was properly denied because there's no reasonable view of the evidence that defendant committed trespass instead of burglary on either occasion. Our primary argument is that the manner in which he committed those crimes kind of negates any potential innocent explanation. In particular, with the Picard burglary, he tried multiple doors before he encountered Picard's unlocked doors, which he left open in case of emergency for her son. He was able to enter the vestibule of a home before Picard, so if he was looking to escape the cold, that was entirely possible. And he was only inside for 5 minutes before she returned, but in that time, he had already gone through her obvious valuables, the pocketbook, to take her wallet and change purse, her laptop, and her boombox. And that's why we believe that the trial court properly denied his request. If there are no further questions, we just ask that you affirm.
Thank you.
Just returning briefly to the lesser included question. I'd like to contrast the legal sufficiency standard with the lesser included standard. Legal sufficiency asks, in the light most favorable to the people, whether any rational trier of fact could have found guilt beyond a reasonable doubt. The lesser included standard looks at the evidence in the light most favorable to the defense and asks, is there a reasonable view of the evidence that the defendant was guilty of the lesser but not the greater? And in this case, looking at the evidence in the light most favorable to Mr. Goldfaden, it may have been legally sufficient, but it did not exclude the reasonable possibility that he entered for an innocent purpose and picked up the Metro cards. There were other valuable items in the house. that he didn't take. When the homeowner, Ms. Picard, came home, he left peaceably. He wasn't looking for violence. And so the court erred when it refused to submit trespass as a lesser. Thank you.
Thank you. Thank you both. Anad v. Guyby.
Good afternoon. May it please the court. My name is Jason Tenenbaum. I represent the infant appellant in this appeal of the summary judgment motion. Quite frankly, the respondent here in this particular case, in their motion papers, did not establish prima facie that my client did not suffer a serious injury causally related to the February 5th, 2017 motor vehicle accident. In the event that indeed that prima facie burden was met, our papers more than adequately raised tribal issues of fact.
How do we deal with the gap in treatment?
Excuse me?
How do we deal with the gap in treatment?
Okay, so in terms of, I think we have to first look, not put the cart before the horse. We don't get the gap of treatment before respondent meets their prima facie showing. And looking at the case law from this particular court, as long as there is contemporaneous treatment, which looking at the Linton case is
What contemporaneous treatment, counsel?
contemporaneous treatment is less than 4 months according to appellate division case law from this particular court.
No, I'm not asking you for the definition. I'm asking you, what contemporaneous treatment did the plaintiff receive?
Plaintiff received psychological and mental health services
From whom?
from a psychologist, from a mental health counselor that was
That was the first person, and that lasted a few months.
working under the license of a psychologist for a period of 3 months.
Yes, that was 3 months at
was
the
3
very
months.
beginning.
But that would meet, Your Honor, that would meet the contemporaneous prong, and that would also show that indeed there was an injury in which my client did suffer PTSD.
Right, but the question has to do with gap in treatment. So with respect to follow-up, once the mother discontinued that treatment for her daughter, what else can we rely on with respect to treatment?
Can I just state before we get the gap in treatment, unless my
No,
understanding...
counsel, can you just answer my question, please?
Answer your question is that we look at the third month of treatment, we look at the treatment note where the practitioner pretty much says, there's nothing more I can do for this 5-year-old infant.
Counsel, which practitioner? Because the person who initially treated the child was Ms. Cobbler from the Center for Coping. It was for 3 months, and she recommended that treatment continue. So who said that there was nothing more that could be done?
I want to look at my note. The record's a little murky on that point, Your Honor.
It's extremely murky because it's not there.
Well, the also issue is that my client's mother at her deposition pretty much said that Bonnie was her name, was how she discussed my...
The treatment records show that the last name was Bonnie Koblenz.
Right, Miss Codlin.
What should we take from the mom's deposition that she says that she's now the therapist?
That she assisted her daughter, a 5-year-old child, who after the accident clenched to this bear that an ENT...
Does that deal with gap in treatment?
Well, the gap in treatment deals with the mother stating there was nothing more that Bonnie could... I used the word Bonnie. That's how she reacted or how she answered the question at her deposition. And so in that regard...
Counselor, other than 3 months' worth of treatment at the outset, I mean, this is really the other issue that's of more concern is the significant limitation, but you're not really responding to the easiest issue here, which is gap in treatment.
But I understand your question, Your Honor, and I earnestly do not believe we get the gap in treatment because there was no prima facie showing of lack of serious injury or lack of causal relationship. I think Judge Mendes, in his opinion, in his dissent, his long dissent, that
So that means you don't have to answer my question.
I always have to answer your question, Your Honor. You wear the robe. appeared before you for many years. I answer your
So let's
questions.
move on and just answer the question.
I'm answering the question. To answer the question is relying on Judge Fernandez's decision, second department precedent, even precedent from this court in which the party making the motion has to prove lack of serious
So
injury.
you're arguing that there was no prima facie showing, so therefore you don't even need to get to gap in treatment?
That's right. We in New York work under a prima facie showing. We don't work under the federal Celotex standard, which is a directed verdict standard. So there was no showing. So we don't even get there, Your Honors. As far as a significant limitation, I understand what Your Honor stated, but indeed there was the 3 months of treatment, and there also were two, if you want to call them, extensive examinations by Dr. Franklin Porter and Dr. Heller with this infant child on this qualitative and quantitative testing did show diminishment, did show a PTSD injury in remission. I mean, the record is clear as a whole that there was an accident. My client did suffer PTSD injury. I understand there were gaps of treatment. However, notwithstanding all of that, there were 2 other visits. Plus, there was the EBT testimony in which my client, to this day, I think this was 10 years ago, is still hanging on to the doll that the EMS workers at the scene got her. At the end of the day,
Thank you. You have time on rebuttal.
Thank you, Judge.
Good afternoon. My name is Evie Kazansky, and I represent the defendants in this action. I will answer your question. This motion was made in the context of a New York State insurance law under the threshold. Therefore, the prima facie is all-inclusive, including a gap in treatment. With respect to the coping counsel, it was, I just want to put this in context. The accident happened a little before this child's 5th birthday. The father's claim has been resolved. Then motion practice continued.
Yes.
At the time of these depositions, she was about 10 years old. Today, she would have been about 14. She is 14. So right now, in the context of this motion, you're dealing with a 10-year-old that had just had a deposition. At that time, no treatment. She's doing well in school. The 2 categories that the plaintiff is arguing about are significant limitations, which, Your Honor, is correct. It's contemporaneous situation and what was going on at the time, and then a permanent consequential limitation, which is at the time of the motion. With respect,
So let me jump into what I perceive as a problem. Is it correct that the person who initially treated the child, the infant, Ms. Koblenz, made a finding that the child had PTSD?
no, she did not. In fact, what was going on was that the child went for 12 visits and then was pulled out. She went from April, which is 2 months after the accident, and went through July. At that time, there was a suggestion that maybe the child might have PTSD and or anxiety. There was no follow-up treatment. In fact, when you read the mother's deposition, the mother actually was getting frustrated with the fact that the daughter was still sleeping in their room and things of that nature. There was no...
Let's flip it. Where is, what proof or evidence did you submit to refute that there was PTSD? Did you submit anything showing that there was not PTSD?
So we relied on the coping counselor's records. There was no affidavit put in opposition. The plaintiff cross-moved. So the plaintiff is relying on his cross-motion for threshold on the same exact 12 visits that we relied on. The fact of the matter is the secondary issue of this gap in treatment, she went to Dr. Porter about 2 years later for 1 visit, and she was 8 years old at that time. At 8 years old, he did a PTSD psychological examination of her and said she was still too young for that PTSD.
She was 10 months younger.
She was 10 months too young. So the law
But
said...
the fact is that the plaintiff put forth evidence that she was suffering from PTSD in the psychological records. You did not, or did you put forth anything to dispute that she was suffering from PTSD? Because I didn't see any, actually I saw that you put forth nothing on your own in the record. You relied totally on the deposition by the plaintiff, mother, and the records.
So for making a threshold motion that we're saying it's not a serious injury, we can rely on their own records. There was no specific finding of PTSD. This
Let me just stop
child
you one
was,
second. Dr. Porter diagnosed the child with PTSD in partial remission. So are we supposed to discount that?
well, that's the part, goes to the gap in the treatment. For 2 years, no treatment. There's supposedly a Mr. Patrick, no records were ever given. Then she goes for one visit where he also gives her a test that he can't give her for her age. So to rely on that diagnosis to say that she could have had some kind of
But
significant.
isn't your issue, isn't your greater issue the significant limitation issue? Let's assume for the sake of argument that we accept your gap in treatment analysis, all right? I mean, she treated for so many months, and then that was it. Mom treated her after that, and a person, a psychologist in Peru whose name we have, but no CV, no treatment records, nothing, right? Okay, so let's deal with the other part.
So with respect to significant limitations, the law is that the PTSD, you can have a psychological. Nobody's denying that you can't have a serious meet threshold, but it has to be serious and verifiable. The coping counselor records with what the child and the mother were saying were going on in her life at that time, she was doing well in school, living life, able to start going back into the car. So when you have the coping counsel records and seeing the child progressively getting better, unfortunately, she's 5 years old at the time. It's very hard and speculative to know whether or not what that PTSD really was when you look at her schooling, her friends, her life.
But that's exactly what you should have done. Bring in competent medical evidence to refute that she was suffering from PTSD. And according to the treatment report, on the very first visit that this child saw the therapist wrote down, she is suffering from post-traumatic stress disorder and experiencing flashbacks and refuses to go in the car alone with her father. So you have nothing to refute this statement from the therapist, and you have nothing to refute the allegation, the claim that she's suffering from PTSD.
The only thing in answer to that I will say about that statement is that there's no discussion. It's a subjective
It is your
situation.
burden. It is your burden as the movement. You're the one that has to bring forth competent medical evidence to refute the allegations in the complaint that this child is suffering from PTSD.
Respectfully, I think that with regards to a threshold motion, we can rely on the plaintiff's own
did.
records and the plaintiff's testimony to show that there was no significant injury that rises to the
Counsel,
level.
you're a layperson. We're laypersons, right? All of us together, we're lay people
Okay.
with respect to the area of medicine. There's one of the diagnostic tests says, oh, you know what, there's a problem here because she scores high on anxiety. Really? You know, there's no proof of normal. Who attacked that? Was it you, or was it an expert who you provided? The issue about her having mild symptom severity with respect to PTSD. What is mild in the realm of a medical analysis? You relied on proof that perhaps under other circumstances would have, landed you a dismissal. But did you meet your burden of proof here that you were the moving party?
I believe we did, Your Honor. Those words that you're using are exactly the words that are used to say there is no threshold. Mild,
But counsel,
insignificant.
Did you
no,
submit anything to state that? Do you have an expert or a psychologist or someone who's going to say that mild means that it does not meet the threshold?
I think the plaintiff's testimony and even Dr. Kobles, who after 12 visits said the child is getting better, does not rise to the
Getting
term.
better. Getting better from what?
She's 5 years old at the time, Your Honor. That's the problem.
Can
That's
I read to you her last statement in her last note, what the therapist says?
Yes.
The therapist says, but therapist feels that she would benefit from additional counseling.
And unfortunately, Your Honor,
That means that she still requires additional therapy.
Unfortunately, Your Honor, her parents did not follow up on that.
But it's what the therapist said. The therapist said she still needs additional therapy.
The problem with that is if the parents, if this was an adult, we'd be having a different conversation. For a 5-year-old, if the parents who control the child have not brought her forward and then bring her to a doctor that does an improper PTSD test, there is no way that a defendant can ever defend that at a trial.
How
or
about
anywhere.
doing a medical examination with one of your doctors?
They're just
or
going to
your
say
expert?
the opposite. That's the problem.
Okay, and so then there will be a determination made as to which expert you are going to agree with.
But for
But the problem also is that unfortunately, you have to take your litigants, you have to take your plaintiffs as they come. And you're dealing with an individual who was 4 years old at the time. Yeah, it probably would have been easier for you if it were an adult and not a child under the control of her parents. But, you have to take her the way she is.
I'm
I understand what you're
Understood,
saying,
and I
but
just-
again, you're
that's-
talking about she needs additional therapy, she's recovering. What is she recovering from?
For what-
PTSD,
Understood,
according
and
to the
what-
records.
What I will respond to that lastly is forgetting the deposition. At the time, in opposition, there is no affidavit saying this child or is saying that she's having any issues. So I will just ask the court to look at the totality, starting at 4.5 years old, 12 visits, the parents don't follow up, 2 years later, nothing. And now we're 10 years later, no affidavit suggesting that this child is suffering from PTSD. To go to a jury on this is purely speculative. They could have waited till she was 21. They could have waited till she was 21, and we would have had a better spectrum of what was going on with her.
Thank you.
Thank you.
I have nothing else, thank you.
Thank you. Castro v. City of New York.
Good afternoon. May it please the court. Ralph Cosentino for the defendant's appellants. Good afternoon. May it please the court. This is Ralph Cosentino for the defendant's appellants. We're appealing from the decision of Justice Socorro, which denied the defendant's motion for dismissal of the Labor Law Section 240 sub 1 and Common Law and Labor Law Section 200 causes of action. This case involves a tile worker who was successfully using a Baker scaffold.
Was rolling the scaffold, one of the legs got caught in the hole and it fell onto her.
Correct.
What's the issue?
Our position that it's the sole she is the sole proximate cause of her own accident because she knew that the scaffold was equipped with functioning brakes. She utilized the brakes while she was performing her work. She came down from the scaffold. She unlocked the brakes. She moved the scaffold into a position that was for her to move some materials, buckets of water, off and onto.
This is something that she always did, right? When she was working, she needed to change the water, so she would come down, remove the brakes from the wheels, move the scaffold, or separate it a little bit from the wall until she was then able to put the buckets back on, and then she would place it against the wall again, put the brakes on and get up.
Correct.
Okay.
Yes.
So what, did anybody tell her, listen, whenever you are gonna refill the buckets up with water, you cannot remove the brakes? Did anybody say that to her?
There's no testimony to that effect, and in opposition.
Don't we have a problem there?
But plaintiff, through her own actions, exemplified that she knew that without locking the brakes, the scaffold had a
How
potential to
did
roll.
she know that? If she
Well-
received no instruction, if she received no directive, if there's nothing in place that says every single time that you move the scaffold, in addition to whatever time you spend on top of the scaffold, you have to lock it because the thing might move on its own.
Well, on page 234 of the record, the testimony is that she acknowledged that when she doesn't, with the brakes aren't locked, the scaffold could roll. And that's exactly what happened here. I mean, the brakes weren't locked and she knew the scaffold could roll, and it did roll. All she had to do was lock the brakes after she unlocked it, and the scaffold would not have rolled. There's no.
But the problem here is not just that the scaffold rolled, is that it fell into a hole.
It did fall into a hole, but it was a hole that was not causing an issue until the scaffold
Did you
rolled.
see I mean, we looked at the pictures. That's a big hole, a deep hole, had rebar on it. It was a serious hole.
It was
So there you have a big scaffold rolling into a big hole.
It was also unprotected.
It was a chipped away portion of the subway platform that was part of the construction
That was
work.
more than chipped. That was dug out. I don't know how they broke that, but wow, is that a big hole?
Still, though, would not have caused an issue, but for the fact that the scaffold rolled into the chipped away area because plaintiff did not.
Why isn't the whole some negligence on the part of the defendants to take it out of sole proximate cause? So if the hole wasn't there, then the scaffold wouldn't have been put in a position where it could be toppled over.
We don't know if it wouldn't have toppled over at some point as it continued to roll because
So
it
let's-
had
actually,
buckets of
that's what
water.
happened. Isn't that correct?
That's correct.
So let's talk about the fact, not supposition.
Well, then that would be more of a labor law 200 or common law issue than the 240 issue because it's now the issue of the plant, I guess, of the.
Why would
platform.
that be a component of sole proximate cause? If the defendant is even 1% negligent by having an unprotected hole or rebar area, then it then makes it clear that there is no sole proximate, which is 100% negligence on the part of the plaintiff.
But the scaffold would not have found its way into the hole if it wouldn't for the fact that she.
That's negligence on the part, let's say, allegedly of the plaintiff.
Correct.
We're talking about the defendant's negligence. By having that hole there, you certainly expose the defendant to some liability. Doesn't matter if it's 1%. Under 240, that would make 100% liability under strict construction.
Well, I understand what you're saying, but the issue is that it could never have gotten to that point if she had not taken the first step and locked the brakes, which she knew that were functioning. She had used the scaffold with the functioning brakes. She doesn't have a good justification for why she didn't break the wheels of the scaffold. She was the sole reason why the scaffold rolled to begin with, and it would never have rolled into the chipped away area had she had locked those brakes. She's the sole proximate cause of the rolling scaffold, which fell because she didn't lock the brakes.
Thank you.
Good afternoon, Your Honors. Peter Riegelhaupt for the plaintiff respondent, Corinne Castro. I think Justice Gonzalez, Justice Mendes, you hit the nail on the head. There was no instruction, let alone an instruction that she disregarded for no good reason, so the sole proximate cause defense is out. Not only does the picture show the size of the hole with the rebar and the depth, it also shows how close the scaffold had to be placed next to the hole for her to do her job. You have two defense witnesses that testified in this case that if anybody was working near that hole, it should have been protected or covered. Both the MTA's witness and the general contractor's witness testified to that effect. So the sole proximate cause defense is out.
Did you make the argument that it can't be sole proximate cause as a result of the hole, or only because of the failure to provide instructions?
I think it goes to both.
Or did you make the former argument that the hole would reject the notion that the plaintiff was a sole proximate cause?
Yes, in part.
You made that argument.
That's one of the reasons, yes.
No, but I didn't see that in your complaint, I didn't see that in the complaint or in the argument to the lower court, that she could not have been the sole proximate cause because of the hole.
Well, we certainly argued that the hole constituted a dangerous condition. We had two witnesses testify to that effect. That's certainly part of the argument.
Was defendants were on notice of this dangerous condition?
Of course, yes. She was there for at least a week beforehand. And she
No,
said
but
it was
you
exactly
made
same.
the argument that the defendants were on notice of the dangerous instrument,
Oh, absolutely, yes.
the dangerous condition, excuse me.
Yeah, the plaintiff testified that it was like that for at least a week beforehand. And as to the Labor Law 200 claim, this is not a means and methods case. This is a dangerous condition case. It's their burden under those circumstances to show that they didn't have notice, and they can't do it here. 'Cause
That's what you argued. You argued a lack of notice as, excuse me, you argued that they were on notice as to the whole.
correct, as to Labor Law 200 and as to common law, but the
Exactly.
facts regarding the whole certainly help on the sole proximate cause argument.
But you argued as to common law negligence and 200.
Absolutely.
Yeah,
Yes.
thank you.
Thank you.
To answer that question, no, plaintiff in opposition to the motion did not argue that the whole takes the sole proximate cause argument out of contention. In fact, a lot of the case law, all the case law cited by plaintiff was just that there are other cases where plaintiffs have failed to lock the brakes on scaffolds, and they were still found to be 240 or questions of fact. However, as I point out in my reply, all those cases relied on by plaintiff have nothing to do with the wheels not being locked, but rather they had to do with either plaintiffs falling off the platform of the scaffold because there was a failure of the guardrails, or there was a scaffold that fell onto the plaintiff because his co-worker pushed the
Did you
scaffold
argue
onto him.
recalcitrant worker?
Well, the recalcitrant worker it goes hand in hand with the sole proximate cause argument, and I do argue that in my brief, both on the motion in chief and in my.
So if you did, then we go back to the same question, and I'm basing this on Noor versus City of New York. How did you establish that the worker was actually instructed to use the safety device, being the locks on the scaffold? Where is it in the record? Because we didn't see it.
It's just demonstrated through her own actions and knowledge with the use of the scaffold that she.
There were no instructions.
There are no instructions in the record.
Thank you.
It's more than that, that there was no failure to follow instructions, correct?
Well, there are no, correct, there are no instructions, one in the other in the
The
record.
standard is, in order to prove recalcitrant worker, you have to show that there was a failure to follow instructions. And obviously, if there's no instructions, there could not be a recalcitrant worker argument.
Again, it's just been our position that through her knowledge that both that she had to lock these wheels of the scaffold while working on it, and that she knew that without locking the wheels of the scaffold would roll, that she was aware that she had to use the brakes on the scaffold to prevent it from rolling, and for no good reason, she failed to do so, which led to it to roll and to go into the hole, causing the accident alleged.
Thank you. Mendes v. Primitive Christian Church. Yes,
I proceed?
please.
Good afternoon, Your Honor. May it please the court, Barry Black for appellant. Your Honor, contrary to the trial court's holding, we never argued that the First Amendment protects sexual abuse. What we do argue is that the First Amendment prohibits the trial court from treating my client as a church corporation less favorably than it would have a secular corporation, such as if the complaint had included Microsoft or Tesla, which has no legal connection with the local church. The same here. I need to note that the General Council of the Assemblies of God is a non-hierarchical church in the sense of governance, unlike the Catholic or the Episcopal churches, which under certain circumstances exercise a certain degree of control over their local parishes. The General Council has 17,000 local.
So, counsel, that may well be. This is a 3211 motion. And what you're saying may well be the facts, right? But on the motion, the issue is whether or not you submitted any documentation, or is any documentation submitted which would negate the possibility as to the supervision and control of the GCAG. So what documentary evidence did you submit that was unambiguous and clear as to control and supervision?
Your Honor, I believe we submitted the very best documentary evidence available to mankind, a statute of the state of New York, section 434 of the Religious Corporations Law, which says that every local church affiliate, including this one, is a sovereign, autonomous, self-governing, and self-determining body.
So let's take a look then, let's discuss the Constitution and the bylaws of the General Counsel, all right? And the documents indicate that there is an interrelationship, notwithstanding the sovereign status of the local church involved here. I specifically refer to the fact that there are disciplinary protocols that are applicable to all ministers, all 38,000 of them. There's a credentiality authority, and that's pretty important here, to the extent that ministers are credentialed by the General Counsel, and they can also be defrocked through the intervention of the District Council and then subsequently the General Counsel. And lastly, there's financial control, specifically with revenue sharing with respect to, for example, the youth programs that are in question here. So to that extent, the documents would not be unambiguous with respect to the oversight that is exercised by the General Counsel and the interrelationship between the smaller bodies and the larger one. How would you parse your argument, given all of your own documentary
And I think
evidence?
my colleague mentioned this, but there was a number of things that she mentioned. I don't know if she mentioned the fact that also GCAG would conduct an investigation and discipline anyone for conduct unbecoming to a minister or indiscretions involving morals. So back to her question.
Yes, Your Honor. I would like to respond to that in 4 parts. There are 4 reasons why that is a complete red herring. Number 1, discipline by definition is post facto. You don't discipline someone until they've engaged in some wrongful conduct.
Yes, but you have the ability to do so. So when you're looking at supervision and control, you're looking at the ability. And I certainly agree with you that it is after the fact, but what one of the determining factors may be that you have the ability to do so.
But Your Honor, the Eighth Circuit in Alfred made that very clear, and we briefed that. The Eighth Circuit analogized GCAG and its relationship with its local church affiliates to that of the bar. The judges on this bench exercise disciplinary authority over my ability to practice law in the state of New York. If my conduct is not befitting an attorney under the rules of this court can then post facto disbar me. But that doesn't mean you employ me, and that doesn't mean you're responsible for my misconduct, and
We are not a
certainly you can't be sued.
We are not
for
a
that.
corporation.
I'm not sure I understand how that.
What I'm saying is that in this context, we're talking about a religious corporation, are we not? A religious.
Yes.
Yes. So we are not a legal corporation.
Yes, but the notion of discipline, by definition, means you have authority to, after the bad act has occurred, engage in disciplinary.
Okay, so assuming we accept that argument, what about the other factors that my colleague mentioned?
I don't know where the trial court came up with the financial oversight. There is no financial interaction between the General Counsel and the local church affiliates.
Tithing, there's no role, there's no relationship with respect to tithing?
Every local church of every faith and denomination has some form of charity, of tithing. And if there is a denomination...
Tithing is not charity, so let's not go there. Come on.
Well, biblically speaking, of course, it
No,
has
we're not
its
going to
roots in
discuss the
charity.
Bible here. We're not going to get into that.
Of course, Your
You
Honor.
know
but
that tithing doesn't mean the same thing as making a charitable donation so that people don't go hungry, right?
Churches and other religious bodies, Your Honor, always support each other. That's part of their doctrine. They want to help the same faith that they believe in. So that's what tithing is. That doesn't mean there's any control by the General Counsel over a local church affiliate with respect to the finances.
The documents that you submitted, none of the documents that I saw discussed in any way the relationship between this GCAG and the youth ministries or the Royal Rangers, those programs. So was there anything in any of the documents that spoke to the relationship as to those two entities?
Yes, those are defined in the Constitution and bylaws, and they are religious programs. They are a template for how you raise Christian youth under the Assemblies of God denomination. That's it. What the local
Aren't they
church does.
aren't they supported by the General Council in part?
I'm not sure I understand the question, Your Honor.
The functioning, so one of the things that the General Council does is assist and support programming, am I wrong, in the local churches?
That is absolutely not correct, Your Honor. That is completely fallaciously alleged by the plaintiff, but it is nowhere to be found in the Constitution and bylaws. GCAG has zero involvement in the local church, in its youth programs, in what they do. All it does is it provides a template. It says this is what the doctrinal approach to raising Christian youth is under the Assemblies of God denomination. It doesn't send anyone to the local church. It doesn't oversee the local church's youth. It doesn't hire or fire youth ministers. It couldn't. By definition, the only authority, speaking of the disciplinary authority, Your Honor, the only disciplinary ability it has is to revoke, to withdraw the credentials. I would like to direct Your Honor's attention to Article 11, Section 1 of GCAG's Constitution and bylaws, which reads verbatim, under the rubric, subordinate in matters of doctrine and conduct. That big word conduct that people have been playing with and saying that means we oversee their conduct. It defines conduct. It says as follows, a general council affiliated assembly shall recognize that a district council or the general council of the Assemblies of God has the right to approve scriptural doctrine and conduct and to disapprove unscriptural doctrine and conduct, and the authority to withdraw its certificate of affiliation if deemed necessary. After whatever has happened, they get to look and say, no, you can't, we're not going to allow you to continue to be a part of the Assemblies of God engaging in that kind of unscriptural conduct. That's it. They can't hire and fire a minister. We've argued in our papers, if the General Council learned that there was sexual abuse, there's a report, it filters back to the General Council, Minister X has engaged in sexual misconduct. They can, until they're blue in the face, direct the local church to fire him. The local church can say no. They have no authority.
If the local church fails to address issues of such conduct, isn't it so that the General Council can investigate and decide whether or not that person will remain a minister an Assembly of God minister?
Yes, long after it's happened, they can.
The answer is yes.
No. I'm sorry, Your Honor, let me clarify my answer. They can only decide whether they are going to revoke his credentials. They cannot decide whether he remains a minister in that church. There are many cases in which ministers in all faiths and denominations have their credentials revoked, but the congregation says, we love our minister, we want to keep him.
The question here is the interrelationship and to what extent it exists. And to that end, is this a matter that really is appropriately the subject of a motion to dismiss as opposed to discovery and the subsequent motion for summary judgment?
And more so to the point is whether or not the documentary evidence or documents that you put in support the statements that you have made. And you'll have time on rebuttal. Thank you.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. I'd just like to start, before we discuss the documentary evidence for a second, I do think it's important to state that the 4th Department in Stewart and the 2nd Department in Escobar has decided these issues. I understand it's persuasive and not binding here, but what's significant is that the exact motion, under the exact basis, with the exact defendants, have been adjudicated already by the 2nd and the 4th Department, and the defendants haven't set forth one reason why this court should diverge from that, and what evidence the Constitution and bylaws, with the exception of a couple sections here and there, are pretty much aligned. There's nothing different, including the affidavit, by the way, of Donna Barrett, which is completely insufficient. Hopefully I'll have time to get there. What I'd like to point out is that this post facto discipline, I just really think that that's taking away the issue of the fact that they have the authority, and I think it's so significant on their own documentary evidence says that they have the right to discipline for any conduct unbecoming to a minister or indiscretions involving morals, completely that comprises sexual abuse. And it's not just about withdrawing the credentials. If you look at the section under discipline, it's Article 9, it talks about it's not just limited to withdrawing credentials. It talks about investigation, determining the discipline, restoration of the credentials, whether they're right to an appeal, whether after a trial, can they then be reinstituted.
It's a whole protocol.
It's comprehensive, is what it is. It's not singular. And this is 3211. That's why the trial court, just like the trial court in the Second Department and the Fourth Department, said, this is too early. We need to develop the record and see what the interrelationship is, which, by the way, the affidavit of Donna Barrett provides nothing, predominantly because she is the secretary of the GCAG in 2018. This happened in 1973. We don't know what was going on in 73. We don't know the interrelationships. That should be explored at depositions. Let them make a motion for summary judgment and see how they do. 3211A7. So another thing I want to point on, which I find particularly, I don't know if the word outrageous is right. This has nothing to do with the First Amendment. Sexual abuse is not a religious tenet. Sexual abuse has nothing to do with the religious doctrine.
Counsel, I don't think anybody's arguing that. Seriously, I mean, we don't have to go down
Well,
there.
my adversary did.
I don't think he is. I would not do,
Okay, I hope
let's
not,
show-
because it's all over his reply brief. Okay.
Can I
Okay.
address your
Sure.
complaint? Don't you say the opposite in your complaint? You have a long complaint with various allegations saying that there is direct control, that there is a connection. On a motion to dismiss, isn't that the burden is on the defendant to show otherwise? What has been brought to the court's attention that would negate or make the prima facie conclusively, whether documentary evidence or otherwise?
There isn't. There's just the Constitution and bylaws, and there's the affidavit of Barrett. And we do allege in the parties and in the facts, we talk about how youth ministries and Royal Rangers, and they're all under the auspices of GCAG, under the control and supervision, and that's how we tie in or allege at this point that they are related to AGOC and under
So-
their auspices.
They can be considered ministers? Are they deputy ministers? Because this looks like the bylaws control the conduct of ministers.
I don't think it's just ministers. It's people that are within the affiliated churches under GCAG, and it is a section, if I don't think I'll have time, because I want to get one more thing in, but I do believe it's not just about ministers. In addition, my adversary is in the best position to know exactly what Castro is. Castro, we allege, was a deacon, a leader, something with regard to youth. I don't know what he was, and I don't know to what extent all of this applies to something other than a minister. But one of the sections, if I ask you to look, one of the sections does say it also involves people that are affiliated with a local affiliated
So
church.
again, this is a 3211 motion, and again, this is why we possibly need additional discovery so that this can be flushed out.
Correct. Can I just say before my light goes? I think that not just with regard to personal jurisdiction, because this may go to personal jurisdiction, I think this goes overarching to the entire case here before you. In Donna Barrett's affidavit, she refers to the GCAG website. So the website is completely before this court. I went on the website on February 3rd when I wrote my brief, and I think this could be the most telling part of the argument. Here's what the website says in terms of the reach of GCAG. The Assemblies of God was founded in 1914 in Hot Springs with 300 people at the founding convention. Today, there are close to 13,000 churches in the United States with nearly 3 million members and adherents. There are more than 86 million adherents worldwide, making the Assemblies of God the world's largest Pentecostal denomination. Thank you.
Thank you.
It is crucial that the complaint, which needs to be alleged with a certain degree of factual specificity, under the Court of Appeals holding in Godfrey v. Spano, can't even allege that the perpetrator, the alleged perpetrator, is an ordained minister. He's either an ordained minister or a lay leader or a youth minister or a plumber or an electrician.
Counsel, does the Constitution or does the bylaws, do they indicate the definition of a minister? Is a deacon considered to be a minister subject to the discipline of the church, for example?
Of more relevance, Your Honor, the only discipline that is provided for in the Constitution and bylaws is over-ordained minister, as I read it to you earlier, and the only option in terms of disciplinary authority is to revoke the credentials.
So I'm looking at the complaint, paragraph 47. At all times, material to the complaint abuser was a deacon, religious leader, teacher, counselor, mentor, employee, volunteer, and/or youth leader at the church. Paragraph 48, at all times, material abuser was a youth and/or spiritual leader at the youth program at the church. At all times, material to this complaint, abuser was an agent, servant, or employee of the church. Why are these paragraphs not sufficient, again, given the fact that this is a 3211 motion?
May I answer that, Your Honor?
Please. That's why I
Under
asked
the
the question.
precedent of this court, I'd like to bring to Your Honor's attention two separate decisions by this court. That highlight that. In Rosenberg v. OSG LLC in 2024, this court held that.
Sorry, what is OSGLC? Because we need to know whether this is in context.
No, I believe that's the name of the company, OSG LLC.
It's a company, not a church or a
Yeah, this is not a
denomination.
church.
So is it relevant to this?
It is. I'm actually, Your Honor, allow me actually to cite a different case. In D. Saines v. New York and Trimaway Figure Contouring LTD, this court held in both of those cases that separate, distinct, and independent legal entities cannot survive a motion to dismiss. That a complaint cannot survive a motion. You cannot bring in a separate, independent legal entity, which we have provided evidence that GCAG is.
Thank you. Thank you both. Levy Chin.
Good afternoon. May it please the court, Jason Burke for the appellant. It's respectfully submitted that the lower court should have dismissed the declaratory action and the fraudulent inducement claims because the documentary evidence utterly refutes those claims, the documentary evidence being the lease with the merger clause that says this is the only agreement and the final agreement between the parties, that the lease that also provides that the person who made the alleged fraudulent inducing statement or omission rather was the lease provides that that person is the plaintiff respondent's broker, real estate broker, and the emails between the parties that show that after the alleged agreement on September 12th that the plaintiff alleges, the parties continue to negotiate. On September 18th, the plaintiff respondent sent a red line edit of a rider to the lease, heavily edited, maybe about 50% edited rider, and stated in the body of that email, I don't know if this is a right fit, I don't know if you understand the obligations between a landlord and a residential tenant.
Thank you.
Thank you.
Good afternoon, Your Honors. Melissa Montanez for Respondent Michael Lee. The lower court correctly applied the standards under 3211 to decline to dismiss respondents' claims for declaratory judgment and fraudulent inducement.
So, counsel, let's take a look at what the documents say, right? We have an email that says, okay, you know, you have proposed, it's a September 12th, 2020, proposed 54-month rent schedule with extensions that would arguably have ended in April 25th. And then we have a lease that's a one-year lease that says specifically you understand that any agreements made before or after this lease was signed and not written into it will not be enforceable. That's at page 32, 27 of the record. And then we look at 33 of the record, which has 3 rent renewals available by way of extensions to the tenant, ending in 2024. Where is the, and this is signed, so this is fully executed. Where is the ambiguity? I don't understand.
Your Honors, the ambiguity is in the fact that my client believed that he had already seen and reviewed the lease terms, and the lease that was provided to him.
What about the red lined document that he sent to the defendant
On September 18th.
on the 18th, saying, you know, I don't know if this is what I exactly want to do.
So you're saying that he believed that the September 12th, that was the lease, the September 12th email, you're relying on that, yes?
Yes.
But then, as my colleague just stated, why then send on September 18th this redlined proposed writers, et cetera, to the lease agreement?
Well, those emails aren't properly considered on a 3211 motion.
Why not?
Because you haven't had a chance to develop the full record yet, and they're not. You know, it's a mistake for the court to evaluate
The
evidence.
emails were from your client to, they were from your client, right? They were generated by your client, yes?
Yes, Your Honor.
And so you're stating that they are, why would they not be relevant?
Well, because at this stage of the case, the court is required to assume the truth of the facts stated in the complaint and just determine whether the complaint is sufficient on its own to state
Did your client sign the writer?
Yes.
So now we have a signed writer that says that the lease ends on 4/24. We have the email with a redlined version of the writer
Generated by your
client. Why would we not, or the court not accept these documents as documentary evidence that utterly refute your claims?
Well, the plaintiff is contradicting themselves in terms of 1 minute they're saying they're relying on the lease, and then the next minute they're saying they're relying on emails subsequent to the lease.
So how do you address the merger clause? The merger clause says that any other prior dealings are subsumed inside this written document, and that's the full agreement between the parties. And the writer was signed, and the writer had the April 2024 end date.
I have 2 responses to that. First of all, a general merger clause is not sufficient to bar a fraudulent inducement claim. That's well established in cases such as Weiss versus Shapolsky, and the merger clause discussed doesn't deal specifically with the rent schedule or the lease term. And secondly, the issue is whether the lease, my client believed that the lease he was reviewing reflected the actual agreement that he made in the September 12th emails.
I'm sorry, you stated that the merger clause is of no consequence?
I didn't state that the merger clause is no consequence. I said that it's insufficiently specific to bar a fraudulent inducement claim.
On reading the merger clause, why would it be insufficient? It expressly bars any prior agreements.
And additionally, at the very, very beginning of the lease and the preamble, it says, you should read this lease carefully. If you have any questions, or if you do not understand any words or statements, get clarifications. Once you sign the lease, you and the owner will be presumed to have read it and understood it.
The merger,
And then it goes on with the language.
Right,
It
the merger
says,
clause, yeah.
yeah,
So I don't understand why would that be? Can you point to something within the merger clause that you're stating would be insufficient?
Well, the merger clause does refer to other rights and obligations between the parties under government laws and regulations. And it does refer to the condominium documents, so it does refer to outside materials, which suggests that the parties' rights and obligations are not fully expressed in the agreement.
Regardless of the fact that it specifically states you should read this, make sure you read this document. Yes, thank you.
Thank you.
I'm sorry, did you have anything on rebuttal?
Real quick, Your Honor, even if the merger clause isn't sufficient, the plaintiff respondent can't say that they reasonably relied on a September 12th agreement, an alleged agreement, when on the 18th they said, I don't think this is a good fit.
Thank you.
Thank you.
People,
Salud.
bless you. People v. Michael Jones.
Excuse me. Thank you.
Yes.
Good afternoon. May it please the court, Assistant District Attorney Max Bernstein for the people. Oh, sorry. Assistant District Attorney Max Bernstein for the people. It's an unusual case that calls for this court to overturn one of its prior decisions, but this is such a case. The statutory language of Article 220 of the penal law simply cannot bear the construction that the opinion in Campagnoni places on it. For that reason alone, that decision should be overruled. But indeed, the reasons go deeper than the straightforward, albeit independently sufficient, reasons of plain meaning. Indeed, not only can Campagnoni not be squared with the statute's text, it can't be reconciled with the legislative history of the provision's enactment or with the accepted statewide interpretation of these statutes in the related context of multiplicative charging.
So what does the statute in this case, what does it state?
It says, this is 22039, sub 1.
Yes, 22039.
It says that a person may not knowingly and unlawfully possess a controlled substance, excuse me, that's 22016, possess a controlled substance with the intent to sell it.
Okay, and 21 USC
Possess a narcotic drug.
841?
Sorry, it was narcotic drug, I apologize. The statutory language.
The statutory language there.
Pull it out, Your Honor. I don't know that I have.
Okay, but so what would be the argument as to why the two, or it is the factual equivalent?
I think the argument, Your Honor, is simply that the only basis upon which this court has ever found that they are not equivalent is that the New York penal law statute includes a specific knowledge requirement with respect to the drugs that one has to possess. And
That you have to know that it is cocaine, or you have to know that it is heroin.
Exactly, as opposed to that it is a narcotic, which is exactly how the federal courts interpret the federal statute. And again, how every other state that has a similar statute interprets it. And indeed, how the Second Department has interpreted it in Tremuta. Given that that's the only basis upon which this court has ever found that they are not equivalent, and indeed that was the only argument that was made below as to why they are not equivalent. The question really before us here is there a plausible reading of the statute under which that specific mens rea requirement actually exists? And the people's contention is that the answer is no, that if you read the plain statutory language, it functions exactly the same way as the federal courts have interpreted 841 and as every other court in every other state in the country that is engaged with this kind of analysis of their own narcotic statutes, and again, as the Second Department has in its controlled substance analysis in 1985, has what all of those courts have found, which is that the knowledge requirement, again, this is straight from Reisman and Ryan, the knowledge requirement in the statute extends to the end of the sentence. The sentence says a narcotic drug, or in the case of the fifth degree statutes, a controlled substance. In those cases, knowingly applies to the word a narcotic drug and not to any specific subset of narcotic drugs within, or any specific drug within that. So the statutory language simply doesn't cohere with the finding in Campagnoni that you have to specifically know which drug you possess.
So as to the finding in Campagnoni, what was the rationale by this court as to why why the specific drug had to be indicated.
There is no explained rationale with respect to the statutory language, Your Honor. Campagnoni just cites to Ramos and Mohammed.
And Ramos talked about a Florida statute, right? The
Ramos
Florida
talked about a Florida
statute.
statute. But I would point out, Your Honor, one of the interesting things about Ramos is that if you read the opinion, the Florida statute actually was sort of a strict liability to crime with respect to knowledge. You didn't have to know anything about the substance that you possessed.
Right, that
Florida
guilt,
statute.
the
So-
Florida statute states that guilty knowledge is not an element of drug offenses.
So the specific knowledge requirement that Ramos mentions was dicta in Ramos because the knowledge requirement that we concede the statute does obtain is itself not equivalent to the Florida statute. So Ramos did not need to announce this new rule about the interpretation of New York statutory law, which wasn't even relevant to the holding in Ramos. And Mohammed doesn't explain its rationale either. It just cites Ramos. And again, the decision in Ramos is dicta, and it's not obvious on its face why this court would break new ground on a question of New York statutory interpretation only in the sort of ancillary collateral context of a predicate felon strict equivalence analysis. One would think that if this really was a core tenet of New York law, it would have shown up in the countless appeals that there have been from Article 220 convictions. And in fact, the only case that we could find where a court really opined on this specific question was Tremuta, the Second Department, saying something that was squarely contradictory with what this court held.
I was unable to find any cases since Campanoni on appeal in this department.
In this department that specifically deal with this question,
Yes.
That's right. And I can tell you why that is, Your Honor, from our office's point of view. And it's pretty simple that the only times that this issue has come up in the non-predicate context,
Yes.
the straight statutory context to which it really deserves to be heard, are acquittals. The Supreme Court is properly instructing jurors, and we've had many acquittals over the last several years, under Campagnoni, that they need to find that the defendant who possessed, say, heroin, but who alleges he thought it was fentanyl, they need to find that defendant knew it was heroin. And juries have been unable to find that in several cases. And so those cases have resulted in acquittals. And as Your Honor knows, we can't appeal an acquittal. So that leaves us sort of bereft of options. And I would just say for a little color, because I think that this is relevant, after Campagnoni, our office did seek leave to the Court of Appeals on exactly this question.
Denied.
And leave was denied. And I grant that this isn't in the record, but I think it's still important color. It seemed to be that one of the big reasons that leave was denied was precisely because this is coming up in this kind of odd ancillary context of strict equivalency. And the Court of Appeals would prefer, I think, to have this case in the straight statutory analytical
That's
context.
it. We don't know why. We don't know. We can't opine on that. And I think the fact that leave was denied, because I did notice that leave was denied, kind of cuts both ways. Justice Mendes?
Answer my question.
Oh, yes. Okay. I did want one other thing in terms of Campanoni. It says the federal crime has a broader knowledge element.
Yeah. That broader knowledge element, Your Honor, is directly connected to the claim that you need to have specific knowledge here in
Because
New
it
York.
says knowingly or intentionally possessed with intent to distribute a controlled substance.
Right, and the only difference, the only knowledge element difference is exactly this knowledge element, that under federal law, it's okay for you to have just known that it was a controlled substance. But again, according to only this court and in only the context of these predicate felony cases, that's not enough in New York. You need more. But if you look at other areas of statutory interpretation in this area of law, and I'd point to the multiplicative charging analysis, that's not how this court has interpreted this statute in other relevant cases. I mean, the multiplicative charging jurisprudence and the strict equivalency analysis are both supposed to be essentially statutory interpretive exercises. They're both supposed to derive directly from what the legislature wrote in the statute, and yet they come to completely contradictory conclusions. The multiplicative charging jurisprudence, Miller and Martin, tell us that the drugs are interchangeable within the meaning of the statute. But Campagnoni in this line of cases tells us that they're not, that unlike the federal charges, unlike in the context of multiplicative charging, unlike every other state in the union, you have to specifically know which in the category of drugs you possessed, which specific drug that you actually had in your possession. That just can't, those two readings do not square. One says the drugs are interchangeable, one says they are not. And
Justice.
He's answering my questions.
Oh.
Well, I know that I've ran my time.
Yes, you do have time on rebuttal.
Thank you.
Yes.
Good afternoon. Karen Brill for respondent. This court should affirm the motion court's order because appellant does not provide a special justification for this court to abandon stare decisis in a decade of its precedent, as well as...
I mean, you always want to abide by prior cases, stare decisis. But if, as the people contend, that the line of cases is incorrect, then we cannot have a line of cases which are incorrect to continue. We have to stop it, right? So can you shed some light as to why there would be this requirement where the federal statute talks about a controlled substance? Why would you have to state what the controlled substance is?
Yeah, so I think that goes to what appellant concedes, which is that because Article 220 has a number of different substance offenses with different levels of specificity, so some that names like specifically cocaine, for example, for those you do have to know the specific drug type. Once you're starting there, what Campagnoni did is it made the entire article make sense, because otherwise you have a case where there are some cocaine offenses where you have to know specifically that it's cocaine. And so you have a mistake of fact offense if you think it's any other drug. And then you have other cocaine offenses, like under 22016, where you wouldn't have that.
I certainly understand your argument in terms of cocaine, but how then can you have a defendant? You have to show that the defendant knew that it was fentanyl as opposed to Xanax or something of that nature. How do you do that?
So I think the Court of Appeals has answered this question in Reisman. In most cases, the act of possession is sufficient for an inference of knowledge. And the other thing to recognize is that in the rare case, I think, where a defendant can prove a genuine mistake and a jury accepts that, there isn't a total escape for criminal liability. They're convicted of an attempt crime.
Right, but with Campagnoni, you can't have that. There has to be a specific allegation.
You can have an attempt under Campagnoni because you would have an intent. For example, if you possess fentanyl that is actually heroin, you have an attempt to possess fentanyl. The mistake that you actually possess heroin means it's not a completed fentanyl possession crime, but you can still have a completed attempt crime. And I want to, sort of underline that the burden here is not to say what the de novo best read is. Is that system so unworkable and so absurd that this court has to overturn it? And the answer is no. The other thing is that Campagnoni...
I'm looking at it from a different perspective, and as you know, I was on the panel for Campagnoni. Yes. So your argument that New York law calls for specificity and the federal law is broader than that, looking at it again with perhaps a different lens, how would you prove that a person knew that they were selling a specific drug that they intentionally sold or possessed? It can be, we can go in either, possession of a controlled substance. It's not possession of a controlled substance. Sale of a controlled substance doesn't say sale of fentanyl, sale of cocaine, sale of heroin. That specificity is not within the statute. So I will dare say in Campagnoni, did we err in following Ramos and the progeny that followed?
So a couple of answers, Your Honor. Ramos isn't from nowhere either. I think the really important part of this is that this is also in the CJI, and the CJI was not modified after this court's decision in Ramos. It predated it. So the specificity requirement has been in this court's law for decades, and it hasn't created the absurdity.
I'm asking you whether it was a mistake.
Yes. So I think the answer is no, because in the average case, like with all intent, there is often the principle, right? It's hard to guess what's in someone's mind, but the circumstances can create an inference. The same is true for the drug intent, and it's the same way that you would have to prove it for the statutes that they're conceding. You have to prove specific drug knowledge, like the ones that name cocaine, the ones that name ketamine, that name LSD. I'll actually sort of point to Penal Law 22016. If you look at the first subsection, that's the possession of a narcotic drug. 22016-4 deals with specifically LSD. And under appellant's construction, you would have to prove the person specifically knew they possessed LSD. So if you adopt appellant's construction, then two different subsections of the same statute carrying the same culpability require different levels of knowledge. That does not make more sense. It certainly does not make so much more sense that we should abandon stare decisis.
I don't know that I agree with you on that. Why would you require different state of mind as to the two subsections?
Under appellant's construction, they have conceded that if the statute names a specific drug type, the person has to know they named specifically that, they knew that they possessed specifically that drug. So 22016 subsection 4 deals specifically with possession of LSD. Under their construction, that person would have to specifically know they possessed LSD. If they thought they had any other drug, any other hallucinogen, they have a mistake of fact offense. Meanwhile, in the same statute, but a different subsection, you have the narcotic drugs. They're asking for a different knowledge requirement that they know they possessed any narcotic drug. That creates chaos within.
How is that different?
Yeah.
Because a narcotic drug can be cocaine, can be heroin, can be fentanyl. So
I think we're talking about the knowledge part.
yes. Yes, sorry, so let me.
Not the substance.
Right, exactly.
So you
It's the
know
knowledge.
you've got something that's illegal.
Yeah, so the construction that appellant has argued for in their brief is not just that you know something is illegal. They have said that for the statutes that name a specific drug type, so for example, the statute 22016-4 that references LSD, you would have to specifically know it was LSD, not just that it was an illegal drug. That is their argument. Whereas for 22016-1, which references narcotic drugs, you would not have to know a specific drug type, just that it was any narcotic drug. So that is a broader knowledge requirement. That creates chaos within the statute. But I do see
that's what I'm saying. I don't see how it does create chaos in the statute. But I'm also not understanding what that has to do in terms of Campanoni, in terms of looking at the federal statute to see whether or not it constitutes a predicate, he would be a predicate under the federal statute.
Yes, Judge Weber, and I actually did specifically want to get to your point on that, because I think even if you completely agree with their argument, it still is actually not a reason to disturb the motion court's order, because their interpretation of 22016 still is not strictly equivalent to the federal statute. And I think that's exactly what we're getting at, because their proffered interpretation of 22016-1 is that you have to know it is a narcotic drug,
yes,
which is different than the federal statute where you have to know it's a controlled substance, because you could have a mistake of fact offense under the 22016 offense that you wouldn't have under the federal statute. So there can be conduct that is that constitutes the federal offense without constituting the New York offense. So at the end of the line, however we get there, we get the same outcome. They picked an analog a New York analog when they chose to try to sentence Michael Jones as a predicate. That is 22016-1. It is not equivalent to the federal statute. And so this court should affirm the motion court's order, unless your honors have any further questions.
Thank you.
So starting with that last point.
Right, so starting with that last point, is it that we don't need to reach Campanoni because under the facts of this case, it wouldn't the federal statute would not be applicable anyhow?
No, it's not under the facts of this case. I think counsel's making a separate argument, which is that, which we also have seen in the strict equivalence analysis in drug crimes, which is that the category of narcotic drugs under 22016 is a different category than the category of controlled substances.
Yes.
So, and I think that would be true, although, as we explain in our brief, that's not really a problem because you can just go to 22006, which says controlled substance, and that would be the strict equivalent. And, Your Honor, I'm usually on this side of the table as the people, and I'm fairly confident that's a LaFontaine issue. That's not what the court counted below.
We create some type of havoc within the statute. That's what I did not understand.
So I don't think there's any havoc within the statute. Counsel is saying the construction we propose. But to be clear, Reisman specifically requires that the word knowingly connect to the end of the statute sentence. So when the statute specifically says LSD, we agree that under Reisman, there's no way to read that statute except you must knowingly possess LSD. But at 22016 sub 1, The statute says narcotic drug, so you must knowingly possess a narcotic drug. And that's not the people's construction, that's the statutory language. And to be clear, to the extent counsel finds it inconsistent that you can defend against the LSD charge with a mistake of fact with respect to LSD and say, oh, I thought it was cocaine, but you can't make the same exact kind of mistake of fact argument with respect to the narcotic drug statute, that was a choice by the legislature.
Right, I always thought that because the indictment will always say to wit cocaine or to wit LSD or whatever.
Right, but that's
I'm looking at the word or. So I'm looking at 220.16, criminal possession of a controlled substance in the third degree, and it talks about, at 1, a narcotic drug, or, number 2, a stimulant, hallucinogenic substance, or lysergic acid, So there's a distinction between the general category of narcotic drug, or,
there is.
And then there's the specificity, and you keep going down, like number 4 is LSD.
Right.
So does that inform us in any way as to how we should construct the statute now?
It may, Your Honor, but I don't see how it's a problem for our argument.
Oh, I don't see it's a problem for you. I'm asking you.
Oh, I think it makes sense to read the statute. I mean, these are, of course, completely separate crimes that just happen to be described under a single statute, right?
There's different categories, and they're also assumed under the same
header, and they're the same degree of felony.
It's under the same article.
But I would just, and they describe a very similar type of crime, right, drug possession. But I just point out there are more differences between 22016 I mean, the LSD provision, for example, is a weight provision as well. It's not just a simple possession with intent provision. It's a weight provision. So these are distinctly different
the LSD
crimes.
is the only one. There's LSD and there's another drug, I can't remember, where it's also a weight requirement.
Yeah, and counsel points out that under possession 5, there's a weight charge with respect to cocaine. And yes, there are specific weight charges that function.
And those have been held up in terms of the defendant must be able to, the defendant has to know the weight of the, depending upon.
That was the rule in Ryan, Your Honor.
Right.
But the legislature actually changed the law.
Changed it, right.
So that's no longer the rule. But
the reason why I'm bringing it up is because in this particular statute quoted by your friend here, the legislature clearly shows its ability to discern between the difference of a category and a specific drug, to the extent that if it had wanted to say specify the narcotic drug, for example, in 2016, it would have done that.
it absolutely could have done. It chose not to, and I think that there's no reason to read that language into the statute. And I would just point out again, if I could, on conclusion, this court has a much longer jurisprudential record interpreting the statute in the multiplicative charging case law. And in that case law, it has been clear as day that it treats the drugs as interchangeable. There is no reason to read the statute as treating the drugs interchangeably in one context, and in a context where there is no meaningful interpretive difference, to then say that actually you need to know specifically which drug you possess in this other context.
Thank you both. Galaza v. City of New York. Yes.
Keegan Steffen, Beldock, Levy, and Hoffman for appellant. I imagine that this argument is going to be focused on some specific technical issues like the standard for motion to renew, objective reasonableness, and clearly established law.
Well, that's the issue before the court, is it not?
It is, Your Honor. I just wanted to put two things up top. That first, at the heart of this case is a tragedy.
So I was on the original Galaza appeal, I think, and Justice Gonzalez as well. So we're familiar with the facts. We're familiar with what occurred. So the issue on appeal, you did not appeal that decision. I don't think you appealed our decision, right? So on this now, the issue is your ability to submit newly found evidence, right?
Yes, Your Honor. On the on the motion for leave to renew, I would argue at the first juncture, when we submitted the motion for leave to renew, the trial court denied it, saying only that it relied on this court's prior decision. That, to me, seems to be a clear abuse of discretion. The motion was based on new evidence that was put before the court. That new evidence was not before this court on the initial appeal of summary judgment. So that reasoning on its face is a very clear abuse of discretion. We then moved to re-argue the motion to renew because of that fact. The trial court appeared to have completely got the fact of the motion wrong. The trial court then denied the motion to re-argue. First, the trial court said that we did not put forth any new facts that we did not convince the court that the court had ignored any facts. But the court went on to say that even if we had convinced the court that it had gotten the factual basis of the motion wrong, the motion would be denied because the prior counsel had not submitted an affidavit admitting that they misunderstood the law on the summary judgment motion.
So we, in the original appeal, we held that dismissal was appropriate because on the basis of qualified immunity, in terms of the use of force, i.e. the officers tasering the decedent, the decedent's conduct, screaming, etc. And then now on your motion to the trial court, you asked to put in additional evidence stating that this evidence would change the outcome of the summary judgment decision. What was the evidence that you asked to put in?
The evidence that we asked to put in was a rebuttal expert report and a bunch of material that the expert relied on, a bunch of best practices sources, including from the NYPD itself. So
that would go to the issue of qualified immunity in terms of the police officer's use of force?
Yes, Your Honor. It would go both to objective reasonableness and to whether that objective reasonableness fit clearly established law.
And why was that not put in on the, was that not submitted originally?
Because prior counsel misunderstood the law. It's in prior counsel's declaration in opposition to the most recent summary judgment that that prior counsel believed that the court could not consider the expert report that was submitted on summary judgment.
Was there an affidavit from prior counsel as to his or her error in understanding what the law was?
Not as to the error, but their declaration in opposition to the motion is clear on its face, that their belief was that
Was there an affidavit from counsel attesting to the same?
Yes, the opposition is itself an affidavit from prior counsel, the opposition to the motion for summary judgment.
Were the arguments related to best practices put forth? I know the expert opinion was not, but the arguments as to police best practices, was that put forth in the other appeal, finding the conduct reasonable?
No, Your Honor. The best practices sources that are relied on are new evidence that have new facts that go to whether the officers acted objectively reasonably. So the standard that we all agree on here as to objective reasonableness is whether these actions were objectively reasonable from the perspective of an officer at the scene. The evidence that we put into the record is training material so that a reasonable officer would have known at the time. And based on that training material, our expert says that no reasonable officer would have believed that Ariel was a threat or that he was resisting, especially after the first taser effect. And so those, we could not have relied on those facts or...
On the original appeal, you may not have coined it or specifically stated that it was best practices, but you did in fact put in evidence as to the impropriety of the police officer's behavior. You did mention that, I do recall this. You did argue that on the prior appeal.
We certainly argued that we believed a reasonable jury could have found that the officer's conduct was objectively unreasonable on the evidence that existed at the time. But now there is substantially more evidence that we believe warrants granting.
Right, but the point is, my colleague asked whether or not you put this in on the prior appeal, and you said no, but you actually did. As I said, you didn't coin it as best practices, and you did not present an expert or any expert testimony or affidavit from an expert as to that on the prior appeal, but you did argue the same on the prior appeal.
We argued that the officer's conduct was objectively unreasonable, but we did not have the facts that we have now to demonstrate why it was objectively reasonable under the best practices and with an expert opinion who is himself a prior police officer and thus knows, can give testimony, expert testimony that goes directly to what a reasonable officer would have believed at the scene.
What prevented you from obtaining that information when you made the original motion?
The investigation we were doing was ongoing when we had to submit the original appeal. So we submitted them both as quickly as we could.
No, but I'm referring to the motion. Why was not that affidavit not submitted in the original motion?
The motion for summary judgment? Yes. Because prior counsel misunderstood the law. Prior counsel got the motion for summary judgment, saw that there was an expert report, and then said the court can't consider this. This wasn't brought up in discovery. It thus wasn't timely filed. But the statute had been changed 5 years prior. Prior counsel completely misunderstood the law, and they said that in their declaration at the time. That was what they relied on at the time. They have declined to offer a new declaration saying that they misunderstood the law, but it is clear from the face of the record. I don't believe that there is any other reasonable reading of the record.
Thank you.
May it please the court. My name is Jameson Davies for the respondents.
Counsel, I want to jump in if I may.
Sure, of course.
So I need to understand the relationship between the standard or the question as to whether the defendants acted in a manner that was objectively unreasonable and their ostensible violation of best practices. How is best practices a standard? And is there such a thing as a deviation from best practices or a violation of best practices? What is the interrelationship between those two?
Sure. Just to preface, I don't think you even need to get to that point, but I'll answer your question first, and then I'll circle back. There is no real overlap between what's objectively reasonable and best practices. On the last appeal, they cited the patrol guide, mostly because they didn't have this expert report in the record. Here, they cite the patrol guide and some other things. But no court has ever held that any things from the patrol guide or any expert's best practices constitutes what's objectively reasonable. That's a question, as they never dispute in their reply brief, and I think this is really important, is that they say there are facts going to whether it was objectively unreasonable. But as the Supreme Court held in Smith, and as they don't distinguish at all, objective reasonableness is a pure question of law based on the facts of the encounter. This court already held, as on the question of law, that based on the undisputed facts of the encounter, the officers were entitled to qualified immunity. And that's why you didn't talk about it, but that's why this is primarily barred by.
My question is, how would this new evidence, this expert report, even go to our decision as to qualified immunity and the use of force by the officers?
It doesn't, Your Honor. That's the main thing. This court decided, as a matter of fact, based on the undisputed facts of the encounter between the decedent and the police, that he was non-compliant and objectively was threatening, and therefore the defendants were entitled to qualified immunity. Nothing in the expert report, whether or not you consider it new evidence or not, goes to that factual issue which this court already decided and which is law of the case. So as this court can easily get rid of the appeal on just the law of the case, the issue is already decided. There's no basis to revisit it. If you want to make a renewal motion to avoid law of the case, you have to show that the party exercised due diligence in unearthing the allegedly newly discovered evidence. As I don't think anyone disputes, there's no diligence in finding this expert report, as the prior counsel didn't think they needed to submit one. I'll make one point also as to the amendment to the CPLR. Even before the CPLR was amended, as plaintiffs concede, the Supreme Court could have considered the expert report submitted by defendants. It just wasn't obligated to do so. The only thing the amendment did is made it mandatory versus discretionary. But even if counsel had been mistaken about the amendment, they still should have known that the court would have been able to consider the expert report submitted by defendants in its discretion and still should have filed a rebuttal if that was what they were inclined to do. They did not. That was a strategic choice. And this court has held that those kinds of law office errors, failing to submit an expert report, are not the kinds of things that justify granting leave to renew.
So, in looking at the different, the 15 items that are set forth here, as to, failing to go back out of the apartment, failing to go hands-on with Ariel instead of using the taser, going through those, are we being asked to revisit our finding that even if the decedent did not subjectively intend to resist arrest, a reasonable officer could have interpreted his conduct as resistant? I mean, is this an indirect appeal?
I think it is, Your Honor. I think, you know, that, and that's why law of the case should apply here. I think it's just an attempt to relitigate what this court and Supreme Court already decided was a question of fact. And it's really an attempt to walk back factual concessions that the plaintiff made in the briefing of the summary judgment motion as to what happened. And I think both the original appeal and this appeal has been an effort to try to walk back those factual concessions. But as this court held, those concessions are binding, and the facts of what happened are undisputed. So whether it's under law of the case, whether it's for failure to meet the standard for a motion to renew, or whether it's for just qualified immunity again.
Would you help me with the chronology a second? So,
of course,
our decision was issued in September of 2024. Presumably, the time to appeal has long passed. When was this? Our initial decision?
Yes.
When was this this affidavit of this expert proffered for the first time?
The expert affidavit was issued while the appeal was pending. So they filed the motion to renew while the first appeal was still pending.
Thank you.
Thank you, Your Honors. Unless there are any other questions, I urge the court to affirm.
Thank you, Your Honors. Just going to address a few of those things in reverse order. The time to appeal actually has not passed for the summary judgment motion. It has never been entered.
No, the time to appeal our decision is what my colleague was referring to.
Yes, Your Honor.
The time to appeal our September 26, 2024 decision.
Yes, Your Honor. I believe that the clock starts ticking on that when the judgment is entered below. That's never been done by Corporation Counsel. In terms of revisiting the summary judgment decision, yes, but with new facts. That's the entire sort of basis of our motion here. In terms of the prior CPL also like allowing the court to do that, that is true. However, the attorneys below clearly didn't understand that because they said that the court could not. That is in their own declaration.
Counsel, what were the new facts? I know that you argued through the expert opinion that best practices were not performed, but what new facts came to light?
Yes, Your Honor. I was going to get to that next. The factual issues, and they go directly to this court's decision on whether this fit clearly established law before as to threatening and resisting. The new facts are the training materials that were submitted by the expert and the expert's opinion on those training materials.
But you had those training, you introduced those training materials on the first appeal. Right. We considered those training materials.
That's not correct, Your Honor. The training materials that are the basis for the expert opinion are multiple hundreds of pages that were not had by prior counsel.
There were training materials that were issued, that were introduced on the first appeal.
There were some training materials. There were not all of the training materials. There are many, many more training materials, including an NYPD video for training its officers on positional
Counsel, that was available prior, so that wouldn't be an excuse. That's not law office failure. That's not doing due diligence.
I believe that was law office failure, Your Honor. They did not inquire as to getting an expert who would have given.
No, getting an expert is one thing, but retrieving materials and retrieving facts would be a discovery process, which you did not do. I understand in the prior appeal that there were certain materials that were submitted, but now you're saying you found more. That's what I thought I heard you say.
I mean, the materials that were, particularly the NYPD video and positional asphyxia, would have been in the possession of defendants, and
that is discovery, correct? That's
right,
not a new
and
fact.
It wasn't turned over in discovery, so that is new.
I think, Counsel, the bottom line is that you're not talking about new facts. You're talking about embellishing and beefing up your argument as to best practices. It's not new facts. It's just that additional information as to best practices. But one of the problems is that in our decision, we talked about that there may be best practices, or you may deal with an individual who has, psychological issues, et cetera, a certain way, and there may be best practices, but under the circumstances and under the facts presented, i.e. that the decedent was neither compliant or non-threatening, that the police were reasonable in their use of force against him, and therefore dismissal was appropriate under the basis of qualified immunity.
The new materials are new facts. They are facts about what the officers were trained on, what reasonable officers would have
Right, what they were trained on. And I understand that, what they were trained on. But again, circumstances presented in this particular case, is our decision, circumstances presented in this particular case as to what the defendant was doing, whether, excuse me, the decedent was doing, whether he was threatening, et cetera, that those best practices and the training, again, was their actions were reasonable, even with their training, given what they were presented with.
But the new evidence goes directly to what as training material, goes directly to what a reasonable officer would have thought at the time. And if a reasonable officer would have thought at the time that he was threatening, that is what the decision relied on previously. This new material says, based on this training, what they saw at the time shouldn't have been considered threatening, shouldn't have been considered resisting. That goes directly to the qualified immunity analysis, both on objective reasonableness and clearly established law.
Thank you. Thank you both. Trump v. Trump. Yes.
Thank you, Your Honor. Good afternoon, and may it please the Court. Lee Crane from Gibson, Dunn & Crutcher for Appellant Dr. Mary Trump. Your Honors, this case presents one question. Can a trial court deny all discovery on a live affirmative defense because the court finds that defense arguably without merit? For 3 reasons, the answer is no. First, Your Honor, the trial court decided on a motion to compel that the affirmative defense was arguably without merit, citing its prior decision in Trump versus Trump. There was no motion to dismiss. There was no motion for summary judgment. The plaintiff tactically decided not to move to dismiss the affirmative defense on this ground. It was live. Discovery was ongoing. In fact, the court at A11 of the appendix itself conceded that the merits of the defense was, quote, not properly before the trial court. It's not before this court either. No case that the plaintiff cites allows a court on a motion to compel to assess the merits, the viability of a live pleaded claim or defense. The question is whether the documents are relevant or material or necessary.
Counsel, are you arguing form over substance? Because we know that there was a prior appeal. We know collateral estoppel. And if you want to talk about procedure, your affirmation of good faith really was not applicable. It was not appropriate. I mean, so if you want to do with procedure, you would be out of the box on procedure too. So either way, if they didn't follow procedure, you certainly didn't follow procedure.
Your Honor, respectfully, we disagree. We believe we did follow the proper procedure. We did meet.
Your affirmation of good faith, it said what?
I don't recall. I don't think it's in the appendix, Your Honor.
So that's the whole point. In order for there to be a discovery dispute, according to the court rules, you must have an affirmation of good faith. Absent that, the court had the discretion to deny the motion.
So, Your Honor, we followed Justice Reed's individual rules, which require the submission of a letter motion that we submitted to his court.
Yeah, but that doesn't obviate you following the other rules of the court. Just because he has his specific rules doesn't mean the general rules that are applicable to all practitioners is no longer in practice.
So, Your Honor, I think we followed his local rules. We also moved for leave of re-argument. They never argued we were in disaccordance with any local rule. Justice Reed didn't find that either. What Justice Reed found was that we were, as Your Honor noted, effectively collaterally estopped. So to the extent there's a form over substance, I do think we meet the form. I don't think anybody has argued in this case, and frankly—
Well, let's deal with the substance. So
yes.
Why shouldn't the collateral estoppel take precedence here?
For 2 reasons. The first, on collateral estoppel, Your Honor, as the court knows, the question is whether the prior case decided an identical issue to the current case. The prior case decided something conceptually different. Taking the contractual release language that is the same language, we concede, the question is, was the fraud claim in that case barred by the release? And specifically, what Justice Reed decided and what this court affirmed was that an unknown fraud claim, that was one of the issues before this court, that an unknown fraud claim existent at the time but not known was waived. No one, at no time, in any of those decisions, considered whether an affirmative defense was waived. It's a conceptually different point. It's a different contractual piece of language. When you look at the 23 things that were released in that contract, and again, these are sophisticated parties. They were counseled. They had a list of 23 things they were releasing. At no time did any court decide, or was it even litigated.
What's the basis of the fraud claim?
The basis of the fraud claim is similar, that the assets were devalued, and that on the basis that. So the factual basis was similar, but the legal question, this court and Justice Reed did not decide that the fraud claim was merit.
The issues underlying the fraud claim are the same issues underlying fraudulent inducement, and fraudulent inducement was specifically litigated.
The underlying factual issues was not the subject of the decision. What was the subject of the decision was whether the fraud claim was released in the contract. And I think that's a very different issue for two reasons. There's a textual reason. This court has to, or Justice Reed has to look at the contractual language and decide those 23 things that were waived, does it include an affirmative defense? We say no. We cite cases, page 7, footnote 2 of our reply brief, where parties regularly waive affirmative defenses and defenses.
Counsel, wasn't one of those waiver provisions a claim? Why isn't this within the purview of the word claim?
We think claim is different from defense. We think it's textually different. There are canons of construction with contractual.
You're not making a claim that there should be a set-off.
Correct. We are not making a claim at all. We are saying that his breach of contract claim should be denied because of this.
Isn't it really a question of semantics? Because it's the same. It's basically the same thing. It was a claim, and now you're setting it forth as an affirmative defense. Why is it not the same?
So we don't think it's a question of semantics any more than any other contract question is a question of semantics. It's about the text. First question is whether it's unambiguous, and we say it is absolutely unambiguous in this contractual text. They did not release defenses or affirmative defenses. Second question, if we were to actually litigate this on summary judgment after discovery.
What release have you ever seen in the world that releases affirmative defenses? It usually says claims. I have not seen one. Have you seen unless it's a specific case, but in general, all release language talks about claims. I've never really seen affirmative defenses.
We cite 4 cases in our reply brief at footnote 2 that do exactly that. They release defenses, they release affirmative defenses specifically, unambiguously. What these parties were—
Bloomberg form has affirmative defenses in it?
Sorry, Your Honor?
Did you look at the Bloomberg form?
I did not. I don't know.
Does it even matter when you're talking about the same issue?
I think it does, Your Honor, because it's a different question. If we were to go to discovery on this question of what the release meant, what the parties, there could be ambiguity in the language. The parties could have depositions about what they intended in this release. They may well have intended to drop their swords, to drop their claims, but to preserve defenses in the future. Defenses are different. Defenses are not entitling our client to any relief, as was the other case. The other case was a claim in which we sought relief, or Dr. Trump, we weren't counsel, Dr. Trump sought relief from the plaintiff on the fraud claim. Here it is purely a defense against the breach of contract claim.
Yeah. Justice O'Neill, you have a question?
No, I was just saying that I'm trying to understand, because it's already been held that there was no fraud in the inducement of the settlement. No fraud in the inducement of the settlement. And now the affirmative defense is, hold it, there was fraud in the inducement of the settlement. And so I think that's what we're all trying to understand, how we're not looking at the exact same facts and how collateral estoppel would not bar this.
I think Justice Reed's fraud language from the prior decision on why there was no fraud in the inducement was about the release. The question in the case was whether this release was procured by fraud or whether it was valid. We are not
challenging. What is the allegation that was procured by fraud?
What
are you alleging that was procured by fraud?
So the plaintiff is claiming Dr. Trump breached her confidentiality obligations. We are saying the contract is what was procured by fraud. She entered into the contract by fraud. It's a different question from whether the release is valid, whether the release itself was procured by fraud. And when you look at his decision, as affirmed by this court, he's focusing about whether there was fraud in procuring the release, not the contract writ large. He's focused on the release because it was
that's not the law. That's extrinsic issue. So you can't do the underlying contract if you have a release. You can only challenge extrinsically the release. You've now precluded once you sign the release. That's what was decided. And you look like you're re-arguing that point.
No, respectfully, Your Honor, we are saying the release on its plain, unambiguous terms does not apply to this context. If of course, Your Honor disagrees, it would bar the claim. But at the very least, we'd have still the procedural point.
Did you not have a fair opportunity to assert that?
In the prior case?
To assert, yeah, that the release and the settlement agreement was fraudulently induced?
with respect to the claim, but no one considered whether it also waived affirmative defenses.
Collateral estoppel is issue preclusion. It doesn't matter if it's a claim, it doesn't matter if it's defense, it doesn't matter if it's a cause of action. It's issue preclusion. If you could have raised it below and you had an opportunity to be heard and there's due process, that whole issue is resolved. There's no significance or differentiation between a defense, a claim, or cause of action. The whole issue is resolved. That's the case law. It's Ryan. Ryan says that specifically.
We are not taking issue with that point, Your Honor. What we are saying is the issue that was resolved is that a fraud claim was released in the settlement, that a fraud defense is different. That's what we're bringing today, a fraud defense.
Reasonable minds can differ.
I agree, but I think also, Your Honor, that's the other reason why it was improper to do this here, as opposed to not on summary judgment, not on a motion to dismiss. This was a motion to compel, where we sought documents to a live...
I'm still trying to figure out, substantively, what's the difference between the fraud claim and the fraud as an affirmative defense?
I think the remedy is very different. The remedy prevents the plaintiff from recovering the damages that he is seeking from Dr. Trump, the plaintiff. It entitles Dr. Trump to no relief whatsoever. It leaves everything else status quo, as opposed to in the other case, Dr. Trump was trying to recover from him. So I think the result, the remedy, is quite substantive and quite different, even if the certain components of the underlying facts are overlapping, because the issue in that case, the holding from Justice Reed on this appeal, is a contractual holding. The holding is that the release waived certain claims. No one touched the question of defenses. It's conceptually different. It gets to the different remedy. It's a defense. It's not an offense. And at the very least, the proper way to go about doing that was he could have brought a motion to strike. He could have brought a motion to dismiss. There was we've heard a lot today about Rule 3211 motions, Your Honor, and none was brought in this case. They waited until we had a fully pleaded affirmative defense. It was the second affirmative defense in the case. Could have brought a motion to dismiss right at the outset. Never did it. Could have raised this argument. I think under CPLR 3101, we are entitled to discovery material and necessary to a defense that is undisputed, remains live in this case.
Thank you.
Thank you, Your Honor.
May it please the court, my name is Michael Medeo with Medeo, Hyatt & Associates, and I represent the plaintiff respondent, President Donald J. Trump. This appeal involves a straightforward discovery ruling that fell squarely within the trial court's broad discretionary authority.
If we look at the release, and we understand that parties are able to contract freely between themselves, a settlement is a form of a contract. The release specifies a whole bunch of things that fall under its purview, right? So the actions, causes of action, suits, debts, dues, sums of money. Can we assume that affirmative defenses, which are not included here, should not be read into the release?
I believe it should be read in, Your Honor. I mean, first of all, one of the words here is controversies, which is sort of an all-encompassing term, and again, we're dealing with...
Say again?
The term controversies is in here, which would include sort of all disputes related to the fraud.
Is an affirmative defense a controversy? I
believe it's a factual question about whether there was fraud. But even beyond that, there's also it clearly waives claims, and their defense is essentially a counterclaim in disguise, because
Why?
As stated in their appellant's brief, they're seeking to void the entire agreement based on the affirmative defense of fraud. So they're seeking affirmative relief. It's effectively a claim. And again, Justice Reed already decided that there was no fraud. He did make a substantive ruling on it. He went through various different points in his decision stating that that Dr. Trump had voluntarily entered into the agreement, that she...
But to the extent that you have sophisticated parties, they're represented by counsel, the release is quite specific. Can we read an additional item that is not included? I mean, I don't see controversies as being inclusive of affirmative defenses or actions or causes of actions. Don't see that. Wouldn't they have included affirmative defenses and even counterclaims that they're not in here? So why should Why should we read something extra when all this thought went into preparing this?
I think the fact that the release is so exhaustive, clearly both parties intended for this to be the end, that neither side could raise this point from this point forward. I mean, the fact that it didn't specifically identify affirmative defenses, again, it identified controversies, demands, claims,
This could have been written, arguably, in a different way so that the inclusivity and the applicability and the breadth of the general release was understood to be really, really, really broad. But here we have a laundry list. So if we have a laundry list, do we not have to abide by the laundry list?
Well, again, I think the main point is that the fact that it involves claims, they're seeking affirmative relief. Justice Reed already held that it was not a valid claim. This is effectively a claim or a controversy relating to whether there was fraud in the formation of the original settlement agreement. And again, Justice Reed had already determined that the settlement agreement and the release were both fairly entered into. So this factual issue has already been decided. It's already been litigated, adjudicated.
So counsel, the prior appellate division decision actually goes through what was litigated. And the decision says that plaintiff alleged the defendant understood and undervalued her assets and induced her to enter into the settlement agreement and the general releases. Thus, the court properly and necessarily addressed the separate issue of whether plaintiff had alleged a fraud separate and apart from the subject general release. Isn't that the issue exactly that we have here? It's the issue. It's not whether or not it's a claim or a defense. It's the totality of the issue.
That's right, Your Honor. It's the exact same issue. This has already been decided by both Justice Reed and this court as well affirmed it. So this is something that is, that has already been decided, and there's no reason to rehash these same issues and give
Lateral stop.
Exactly, Your Honor.
Thank you.
Thank you.
Your Honor, if I could make 3 brief points. First, you heard my friend on the other side say that the parties, what the parties could have intended, that it should be read in. These are summary judgment arguments, that the parties should have the opportunity to develop in depositions. We're talking about, we've been arguing today about parole intent, about the scope of this release. We may disagree on what the unambiguous language says.
Counsel, I may agree with you in terms of, it's a laundry list, and so therefore, why would we not include affirmative defenses and counterclaims? But again, it goes back to this issue that we're talking about a fraud claim and a fraudulent inducement affirmative defense, which is basically the same thing. I know you're arguing that, well, the remedies would be different, but the substance is the same. The substance of the, I don't want to use claim, the substance of the argument or controversy is the same. So that's why I don't really see that even if you had affirmative defenses in there, that it would really make that much of a difference.
Well, I think the underlying factual, I grant, Your Honor, the underlying factual basis is overlapping. I don't want to say claim or defense either for this context, but I understand where you're coming from.
We use the word issue?
Well, I don't think, I heard the language that you read. I don't think that was...
Language of the appellate division talked about the issue. We didn't talk about it in specific terms, but the issue itself has been raised and for better or worse, has been decided.
I think it was, I respectfully disagree, Your Honor. I think when you look at the motion dismiss ruling, it was a 32-11 motion, I believe. The question was whether that the unknown fraud claim had been released under the terms of the language. That was the issue that the court decided, I think, respectfully.
True.
And then the question of whether there were separate factual bases for fraud, I don't think any court resolved that on the merits because none of the merits wasn't litigated. The merits didn't come out.
Because the release had waived those arguments.
Waived the claims. I don't think it waived
resolved the issue.
I think the release resolved the question of whether our client can get affirmative relief on the basis of fraud, no question. But whether fraud can stand as a defense to efforts to get potentially, they're claiming hundreds of millions of dollars in damages, it is a meaningful difference to our client that whether this defense comes in. I understand the factual basis is the same, but the outcome is worlds apart. it is clear in the case law, remedies are substantive, right? The difference between a defense, the outcome, whether this contract, whether our client gets damages from it, which she's not seeking, that we were saying this was a counterclaim in disguise. It is not.
So your proposal is what? That we reverse Justice Reed and do what? And then it goes back for a determination as to
we
the
would,
affirmative defense of fraud?
so the case is still in
Fraudulent
discovery.
inducement?
The case is still in discovery. We would respectfully request that you reverse and direct Justice Reed to compel production in response to RFPs 2, 3, and 4, which is on Respondent's Appendix 91 to 93. We would go through discovery. There may not be any documents. We don't know because they haven't searched. If they come out, we will then do depositions. We will ask many of the parole evidence questions we've been talking about today, and we'll have a summary judgment record. Presumably, my friend on the other side will argue it's still released. Justice Reed will have a full litigation record before him about what the language meant of that release.
So we're relitigating the terms of the release and whether or not there was fraud in obtaining the release.
No, you are not relitigating.
No, what you're talking about now is relitigating the determination by Justice Reed in terms of the fraud.
In this case.
Yes.
Correct. And to be clear, Justice Reed said he was not deciding that. He said it was arguably without merit. And he said the question of whether the defense was viable was not properly before him. So if that's the only basis, he didn't say the documents were relevant. He didn't say they were burdensome. There's no record on burden. He said he really thinks the defense doesn't have legs. He might rule that way on summary judgment at the appropriate time, but to use that one thing as the basis for denying discovery here, it completely withers the defense on the vine, which I don't think is what the CPLR provides.
Thank you.
Thank you, Your Honor.
Canara Bank v. MVP Group.
May it please the court. My name is Adam Finkel, and I represent the appellant in this action. This consolidated appeal arises from two decisions entered on the same day by the trial court. The first decision erroneously granted summary judgment to MVP, denied Canara's claims in their entirety, and denied Canara's cross motions. In its motion, MVP's primary request for relief was for a finding that the principal and interest components of Canara's claims were paid in full at a foreclosure because the trustee's allocations in the trustee's deed arising from the foreclosure exceeded the actual amount of principal and interest on the date of the foreclosure. In opposition to MVP's primary request for relief, Canara highlighted that MVP failed to make a prima facie showing because it improperly calculated the interest and principal.
Counsel, can I redirect the conversation to the discontinuance? Let's deal with that first.
Okay.
Was it proper or not proper for the court to permit the discontinuance?
Okay. Our cross motion for discontinuance, well, the trial court should never reach the merits of the case. This was a motion for partial summary judgment. It wasn't a motion for a complete disposition of the case. And neither MVP nor the trial court identified any special circumstances that would warrant the denial of our cross motion. We had informed MVP several weeks before they filed their motion for partial summary judgment of our intent to pursue this matter out of state in Tennessee and North Carolina, which we believe is...
Did you know that they were preparing to make a motion for summary judgment at that time?
Well, we had an oral argument in which they said that they identified that there was a foreclosure proceeding that may have impacted our claims in this action. And we said, wait a second, we have claims of our own and challenges to that foreclosure proceeding. And the court encouraged us to try and resolve that amongst ourselves. So that's exactly what I did. I reached out to opposing counsel. I said, hey, look, we have these issues. There's a Tennessee deed of trust. This is a Tennessee property. This is a Tennessee foreclosure, Tennessee trustee. everything points to having these issues between us resolved in Tennessee. There was absolutely no reason for MVP to file a motion for partial summary judgment in New York, which had absolutely no chance of, well, it shouldn't have resulted in a complete disposition of the case. At this point, in making this motion for partial summary judgment, they completely failed to establish a prima facie showing because they miscalculated the principal and interest. And then in opposition, Canara highlighted that they failed to make a prima facie showing, but Canara never stood behind the trustees' allocations, and Canara never offered a calculation of its own because the burden of proof never shifted to Canara to do so. In reply, MVP doubled down on its erroneous calculation and said, you know what, at the very least, the interest in principal is between $10.795 million and $10.803 million, being extremely non-committal. This created an issue of fact. Now, MVP would like to say, you know what, the trustee's deed is prima facie valid. And that is true with respect to certain aspects of the trustee's deed, but not the allocations therein. Tennessee Code 245101, which MVP relies upon, it establishes that, or it states that a trustee's deed is only prima facie valid with respect to the recitals stated therein, and only to the extent that those recitals establish the power of the trustee to convey the property at a foreclosure. It does not reach the allocations which are not part of the recitals and are not intended to establish the power of the trustee to convey the property. For that reason, the trial court didn't say, you know what, yeah, their calculations are incorrect, but we're going to use the trustee's deed and say that, you know, the principal and interest was satisfied because the amount of principal and interest on the foreclosure date was $10.803 million, and that's what it says in the trustee's deed, so that was paid in full. No, the trial court did a calculation of its own, which was tremendously erroneous, and imposed an obligation on Canara to pay MVP $200,000. And that underscores the importance of finding out what the principal and interest was on that date.
You have time on rebuttal.
Robert Gross of Barclay Damon, representing the respondent MVP. Addressing the motion for summary judgment, in the October argument before...
You mean a motion to discontinue?
I'm sorry?
The motion to discontinue or the motion?
The motion for summary judgment to dismiss Canara's complaint, which the court granted. The court determined that after Canara purchased MVP's warehouse in an auction with a credit bid in the full amount of MVP's loan, that Canara's New York complaint should be dismissed, seeking collection on that loan. Canara made the frivolous argument in the October argument before this motion was made that a bank can bid the full amount of principal and interest at an auction sale and still seek millions of dollars if they subsequently sell the property for less money. In this case, Canara bid $10.8 million for MVP's property in Tennessee, sold the property for less, and told the court on in October of 2024 that they were going to go forward and sue continue their suit for $3 million. The court almost invited a motion for summary judgment at that point because the law in Tennessee is the same as it is in New York, which is that a mortgagee who bids in the full amount of the debt.
Counsel, my colleague has a question.
I'm sorry.
It's okay. I have a question that's going to assume that the plaintiff accepted the property in full payment of the debt. Okay, I'm just going to say that.
Yes.
Don't we still have a controversy as to how much money is owed with respect to collection and other expenses?
Yeah. Your Honor, let me address that. The court below considered principal, interest, and expenses. And wrote on all three of them in the January 1 decision. Specifically, the court said we had made a prima facie showing by the trustee's deed, sale deed, showing the application of the funds first to principal, then to interest, and then to expenses, with a $10,800 expense portion, then broken up, attorney's fees and the like, and then turned to Canara. And Canara, the court ruled specifically, fails to offer an alternative which is wholly inadequate on a motion for summary judgment. Then the court did its own math, but on expenses, the court addressed it. Canara put in an October 2024 notice of default that they served in North Carolina, an attorney, 8 months after the auction, with a bunch of expenses that had to do with ownership of the property, not with collection on a loan. And the court looked at them and looked at the October notice. It had such expenses as landscaping and the like, and the court said, none of this is documented. She said it's completely undocumented. So you have not, they met their burden they shifted the burden to you. They made a prima facie showing. You came up with nothing, as counsel has acknowledged here today. And the court said, that's it. You don't have, you can't pursue your complaint any further. The argument that they then came up with other arguments, which I haven't heard today, and as to why they should be able to pursue them, but I'll tell you right now, the main one was a fraud argument, and the bottom line was, it's undisputed in the record, and the court cites it, that 6 weeks before the auction, they received an $8.6 million credit bid, excuse me, a $8.6 million appraisal for the property, and then they credit bid $10.8 million. That's what they're here about. And the court said, that's your problem.
So you're saying that there's nothing left to be resolved?
There's nothing left to be resolved, yes.
Because the issue as to expenses of any sort have already been subsumed in the initial order?
Yes, the judge addressed specifically the October 2024 notice of default, which had a list of expenses, went through them and identified them in her decision and said, you haven't documented any of these. They're undocumented. And that's, I think, at pages... It's in the October, it's at pages 8 and 9 of the record.
Thank you.
Okay.
I just wanted to make a couple of quick points here. The collection expenses were never at issue. If they were at issue, Mr. Gross and MVP would have made a motion for complete summary judgment. They did not. They made a motion for partial summary judgment, and they sought a finding that the principal and interest was paid in full. Now, Canara's claims, as per the promissory notes and its complaint, were that the debt consisted of three components: principal, interest, and collection expenses. Now, I know Mr. Gross would like to sweep them under the rug as they're not important, but in the North Carolina acceleration notice, there was $163,000 in unpaid taxes that MVP didn't pay, that imposed a lien upon the property that we had to clear before we can obtain title. There was recording fees, there were legal fees, there were a number of expenses that the promissory notes and the loan documents entitle us to. And the reason why we didn't substantiate them in the trial court papers is because they never made a prima facie showing. This wasn't at issue. They were seeking partial summary judgment for a finding that principal and interest was paid in full, not collection expenses. So the burden never shifted to us to establish our collection expenses. Not to mention, this was a pre-discovery motion. They had no basis to say what our collection expenses were and whether they were paid, because they never took any discovery. So this is merely an attempt to adopt a clear mistake by the trial court. And if you look at the trial court's rationale on the record on appeal, page 9, you'll see that the trial court made an oversight. The trial court wasn't saying that they dismissed the entirety of our claims because principal, interest, and collection expenses were paid. The trial court did an erroneous calculation, determined that the principal and interest that was set forth in the trustee's deed exceeded that calculation, and then, based on that and only that, dismissed the entirety of our claims.
Thank you. Thank you both. Shuford v. the City of New York.
Good afternoon. May it please the court. Mackenzie Fillo for the appellants. This court should reverse and dismiss the complaint in its entirety. Shuford's claims related to her arrest accrued the day she was arrested and released. That was May 6, 2019. Her notice of claim was due 90 days later, and her complaint was due a year and 90 days later, and both were served and filed long out of time. To the extent that she requested permission to serve a late notice of claim, she didn't even make that request until after the statute of limitations had expired, and courts have no discretion to allow late service once the statute of limitations has expired. And probable cause also defeats both federal and state false arrest and malpros claims here. There was both an indictment from a grand jury and an arrest warrant from the criminal court. This is not a case where the cops arrested someone on the street based on their own judgment. There was a scheduled, she turned herself in to the police. It was all scheduled in advance. Under these circumstances, there was a presumption of probable cause from the indictment and the arrest warrant. And Shuford had to allege specific facts that would overcome the presumption of probable cause if true, and her complaint contains none. She had to allege some kind of fraud or misconduct on the part of the city to procure the indictment and the arrest warrant, and there are no such allegations in the complaint.
Thank you.
Thank you.
Reynolds v. Ford O'Brien, LLP.
May it please the court. Andrew Bluestone for appellant. The complaint in this case stated a cause of action for legal malpractice. Supreme Court did not disagree that the complaint itself stated the cause of action for legal malpractice. The complaint pled that departures came and caused a bad result. Supreme Court did not disagree that a bad result to the plaintiff took place. The complaint pled that Axios double-dipped and received a set-off of $7.5 million that never went to the credit of the plaintiff. Supreme Court did not disagree with that particular allegation. The complaint pled the defendants did not adequately investigate either the set-off or the bias allegations against the arbitrator. Supreme Court did not disagree with that. Defendants brought up the set-off late to the arbitration after all the testimony had ended in an emergency motion. The emergency motion was made late, and there is absolutely no understanding, or I should say no agreement, on the ambiguous issue of whether or not the arbitrators took the motion in and procedurally denied it because it was late, or took it in and ruled on the merits of the motion. The documents before Supreme Court are ambiguous on that. There's absolutely not a single line anywhere that indicates that the arbitrators considered the emergency motion on the merits.
It's not in the award?
No, sir. I challenge anyone reading the actual words of the award to say that they took in the motion and considered it on the merits. They say that the motion was considered, but not considered on the merits.
So it's got to say, we received this documentation from the attorneys, and we have considered it. And
that's what they said.
Right.
They didn't say whether they allowed the late emergency motion to be heard on the merits or not. And it's just the same as we heard two arguments ago in which—
On semantics.
I'm sorry?
The same, it's semantics. Because it was not stated that we considered it on the merits, then we cannot assume that that was done?
Well, that's true. And here's the example that comes up before this panel or other panels all the time. A motion to re-argue is made. The motion to re-argue is denied. Was it denied because it was made 45 days after the original motion? Or was the motion denied because the court did not misapprehend a question of fact or law? It's not appealable if it's just denied because it's late. It's appealable if the court takes in the motion, decides the motion on the merits, and denies it. And that is always, that's constantly being debated and heard before these panels. So it's not just a matter of semantics.
There's no debate when the court specifically states the basis for the denial, the basis for the dismissal.
Well, if a court denies, simply says the motion to re-argue is denied, and then someone wants to appeal it, the other side said it's not appealable.
Well, we don't do that in the First Department, and the judges here in the First Department and Supreme Court know how to write a decision. But I'm not understanding your argument in terms of the arbitrator not stating specifically what he or she considered.
My argument is that there was definitely a double dipping, and my client should have gotten $7.5 million to his credit in the arbitration. Had the motion been made on time with the proper paperwork, it would have been considered, and on the merits, it would have been decided, no, this is not a set-off that goes to you because A, B, C, or D. It would have had to be a reasoned decision. It was not a reasoned decision, and I challenge anyone reading the actual award, in which it says it was considered, to know that they considered the merits of.
So did the arbitration, the award state or the decision state the basis for coming to that 7.2, coming to the decision as to the 7.2 cutoff?
It did not, Your Honor. It did not sufficiently so that a motion to
sufficiently. Did it explain it all?
No, Your Honor,
basis?
it did not.
It said nothing about it.
Our position is no.
Well, yeah, but I'm reading it and I may disagree. There
Your Honor, where does it say why the $7.5 million
Well, it talks about it.
Applies or doesn't apply? It doesn't say that.
Isn't it really a holdback, not a set-off? That 7.5 million?
Well, it's a holdback on Axios' side, but they can't get payments twice. They're getting $7.5 million that they're holding back on the same debt that my client is required to pay, and my client is getting zero credit for that. So it's a holdback on Axios' part, but it should be a credit to the judgment against my client.
Well, it says after consideration denies the 7.2 set off.
After consideration, but did they consider on the merits or because it was late? We don't know. And in the 3211 motion, we should have been given the opportunity to flesh that out.
Thank you.
Thank you.
Thank you, Your Honor. You're absolutely correct. The motion court held that the panel.
Counsel, could you make your appearance?
Apologies. Spencer Richards, for respondents, Fort O'Brien. May it please the court. Your Honors, you're absolutely correct. The panel here considered the post-hearing submission. It says it at the record, page 74. The panel explains that after considering the pleadings, the testimony, and evidence presented at the hearing, and any post-hearing submissions, the panel decided in full and final resolution of the issues submitted for determination before the panel. That means the panel considered the post-hearing submission and decided not to offset the award in the amount of $7.5 million.
The argument is that they may have considered it, but not on the merits. So do they need to state that they considered it on the merits?
I don't know what rule that is. I've never seen that. I've seen Supreme Courts, arbitrators just issue one-line rulings. This is what the panel ruled, and it's explained why in Axios' motion, opposition to the motion that was submitted to the panel.
Well, it actually went a little bit further than that because it did say what it was considering in terms of rendering its decision as to the denial of the 7.2.
It does, Your Honor. But to go deeper than that, Axios explains in opposition to the emergency motion that this is not a payment that Axios received. This is a holdback pursuant to a merger agreement that Mr. Reynolds is not a signatory to. Axos goes on to explain, you can look in the record at page 180 and 181, that there are 4 separate occasions where Legion, the entity that sold Axos, the clearing company, defaulted. And as a result of those defaults, all 4 of those occasions occurred well before Mr. Reynolds' conduct. As a result of those 4 occasions, Axos is withholding $7.5 million. Axos goes on to explain in the opposition that as a matter of law, even if this were a payment under Florida's collateral source rule, Mr. Reynolds is the tortfeasor and he is not entitled to a payment because from Axos, who is the victim. That's what the arbitrators considered. It was completely irrelevant to Mr. Reynolds, and so they just denied offsetting the award. And one other important issue here, the Delaware action is ongoing. Legion may well be entitled to the $7.5 million. And so it is entirely speculative that Mr. Reynolds is somehow entitled to it. He's not even a signatory to the merger agreement. And so for all those reasons, the panel considered the evidence, did not offset the award, and the motion court correctly held that the Delaware litigation, even if it were submitted earlier on in the arbitration, it would not have changed the outcome of the arbitration. So Mr. Reynolds is solely responsible for the $16 million award.
So, counsel, your friend says, but this decision wasn't specific. It didn't say anything about the merits. And everything that you've talked about so far has dealt with the merits. But nonetheless, he says, well, but one particular application was not resolved on the merits. We don't know. My question may be somewhat rhetorical, but in considering, I'm sure you're familiar with what Supreme Court short-order decisions look like, where you have to put down a considered this document and this document and this document. Is there anything similar with respect to arbitrators, the manner in which they write their decisions? What's the type of specificity that has to be included? Or is that something more generalized than what, for example, Supreme Court would have to do?
In this specific instance, the parties did request an explained decision from the 3-panel arbitrators, and the arbitrators did explain their decision as to why Mr. Reynolds is the sole party responsible for the $16 million award. Because they did not explain why they weren't offsetting the award pursuant to some irrelevant information from Delaware, that does not render the decision without merit. It's just Mr. Reynolds claiming here, begging for $7.5 million after destroying Spartan and causing a $16 million deficit in their proprietary trading account. And like you said, Your Honor, judges all the time, they check a box and say case disposed. They have one-line orders, motion denied, motion granted. I've seen orders where it says see the record, motion denied, and doesn't say anything else. It's never been a semantic issue for a judge to decide whether they need to be very specific about why they're denying a motion or not.
Best practices is not to check a box. Thank you.
Not a question of best practices, Your Honor. A question of whether it's a
So,
department.
but let's go to the merits then. What, assuming that it wasn't considered, in considering it, how would it change the position? How would it change the outcome?
Not the outcome of the arbitration, the outcome of the judgment against him for $16, $18, $20 million, where he should get a credit of 7.5.
Based on what?
Based upon the fact that Axios, which is getting the judgment against him, can't double dip like that. It's not fair. It's not equitable.
How is this double dipping if it's a set aside?
Because they're getting $16 million against defendant A and getting $7.5 million from defendant B, and it's the same debt.
Why isn't it premature? Why can't you just wait and see after the holdback? It may even go back the other way. A holdback means it's held in like an escrow account.
Judge,
Why wouldn't we just
I have
wait?
a judgment against my client. I can't wait.
Why? I'm not.
Because there's a judgment against him, and the statute of limitations is ticking by. Of course we have to do something now.
So my point is it's premature. I'm not saying you should wait. We don't know if that's going to be a set-off or not at this point.
That would be an excellent way to decide this case, that it's premature, and the judgment can't stand.
No, what I'm
that
saying
was
is
remanded
you're
for
premature.
You're premature.
Not that this is premature. You're
I have a
misinterpreting
judgment
my
against me.
words.
I can't be premature, Judge.
Okay.
Thank you. Taquan, withdrawn. People v. Taquan Wilson. Withdrawn. Last case for argument. Yes, please proceed.
Or Taquan Wilson, Claire Glass with the Legal Aid Society. Your Honors, nothing in this record moved the needle from level 2 suspicion to level 3. Plainclothes officers from an anti-crime unit approached a teenager sitting in the passenger seat of a double-parked car.
Twice, right? Didn't they approach it twice? He was seated.
No.
Didn't they go around the corner or something and they came back and he was still there?
So, Your Honor, initially the officers observe the car and they keep driving and they go
Right,
around
they
the
circle
block
the
without
block, right? And the
interaction.
car is still double parked.
Yes, and it's about a minute that passes between the officers' first viewing of the car and their decision to engage.
And we have a body cam.
That's right.
So we can see all of this on the body cam, right?
Yes, we can, Your Honor. And what the body camera footage shows is that what the officers knew at this point was that a traffic infraction had been committed. Mr. Wilson was not the owner and operator of this vehicle and in fact wasn't licensed to drive in the state of New York. So that traffic infraction that drew the officers to the scene was not even attributable to Mr. Wilson. And he offered no fewer than 5 times to call his girlfriend, who was upstairs in her apartment getting something for her daughter. And Mr. Wilson said, you know, she would come down and she would move the car to resolve the only...
Is all of this on the body cam?
It is, yes, it is, Your
Okay.
Honor.
Well, they ask him his name, right? At some point, don't they ask him his name?
That's right, Your Honor.
Okay. He tells them his name. He has no ID.
That's right, he has no ID.
But while this is occurring, isn't this when they smell the marijuana?
Well, you know, Your Honor, I have a couple of responses to that. The officers never mention the odor of marijuana in the body cam footage. That only comes up at the hearing. But you are correct that Officer Cruz, who walks around the front of the car, mentions that he sees what he describes as marijuana roaches in the center console, which, you know, is really, this is the remnants of previously smoked marijuana and no mention in real time of any odor whatsoever. So with this information, a traffic infraction that's not attributable to Mr. Wilson and perhaps the remnants...
We have the traffic infraction and then we have the smell of marijuana. We have perhaps an issue as to lack of identification. Isn't that enough to ask the defendant to step out of the vehicle?
Well, sure, Your Honor. Perhaps the officers were allowed to ask Mr. Wilson to step out of the vehicle, but that doesn't mean that the officers had a level 3 suspicion at that point.
Okay, so it's at the point that he steps out of the vehicle, that's the point where apparently he grabs his waistband or something. He makes a motion towards his waistband area, right?
So, Your Honor, I want to be very clear about what the video actually shows. Now, and additionally, what the officer testified to. So, watching the video, Mr. Wilson steps out of the car. As soon as he is standing, the officers immediately order him to turn around and face the vehicle. As soon as he begins to turn, Officer Cruz touches Mr. Wilson's arm to hasten the turn. And at the same time, Officer Oswald grabs Mr. Wilson's left hand and immobilizes it on the roof of the car.
But before that happened, didn't he sort of like make a move or move his left arm towards his waist area?
Well, Your Honor, as the prosecution concedes, that's not captured on the body-worn camera, and also...
I saw that in the body-worn camera.
The prosecution...
I watched that video many times.
His arm or his hand seems to move in that direction.
Well, again, you know, it's certainly not clear. The left side of his body is not clearly depicted on the body-worn camera. That is certainly what the officer says, but importantly, the officers have ordered him to turn and are already touching him by the time his left side is visible at all on the camera. So what this means is that this order to turn, which I think we can all agree demonstrates that the officers intended to frisk him by that point, precedes any of the moments that the officer points to, you know, raising the level of suspicion. And
why at the point that he makes this movement towards his waistband would that not give the officer, I mean, the testimony was that they feared that he had some type of a weapon. Why would it not give them the right to at least pat him down and frisk him at that point in time?
Well, Your Honor, the officers, again, The body-worn camera doesn't show the touch clearly. It does not show any, it doesn't show the left side of his body clearly. So by this point, they have a young man in a car with a traffic infraction not attributable to him, a very small amount of the remnants of marijuana. And again, they tell him to turn before there is anything going on Mr. Wilson's part in terms of movements. He's simply gotten out of the car at the time that the officers order him to turn. So all of these moments that the officer testifies to as raising the level of suspicion actually happen after the order to turn and the initial touch. And I also want to be clear that reasonable suspicion, even if your honors believe that at the time Mr. Wilson exited the car, that the officers had reasonable suspicion, they had to have an additional and separate suspicion on top of that reasonable suspicion that Mr. Wilson was armed and dangerous. And nothing in the mere seconds that transpired between ordering him out of the car and physically hastening his turn after ordering him to turn led to a reasonable fear that he was armed and dangerous. This is a kid in a double-parked car waiting for his girlfriend to come downstairs. He's got nothing to do with this car. If the car was just sitting there and the officers came around the block a second time, they would have put a ticket on the window. They didn't even need to identify him or even the driver to make sure that there was a ticket. And,
So you're saying that the smell of marijuana and the observing the remnants of marijuana inside the vehicle's console, that was not enough for them to order him out and to conduct a frisk?
Well, what I'm saying, Your Honor, is in our view, that was a level 2 at that point, because once he's out of the car, this is a Terry stop. The infraction is not his fault. He isn't the driver of the car. So once he's standing outside the car, this is a level 2 Terry stop at a time when marijuana is decriminalized and can be dealt with.
No, it hadn't been decriminalized.
No, it had not been decriminalized.
It had been decriminalized, but not yet legalized. So the officers were...
Which is a difference, right?
It is a difference, certainly, but with...
Not semantics. You have time on rebuttal.
I do agree, but just to be clear, they could have given him a $50 fine.
Good afternoon, Emily Ann Aldridge for the People. Almost all of defendant's arguments, including those related to suppression, are foreclosed by his valid waiver, which followed the model colloquy, essentially verbatim. Only the Bruin argument survives the waiver, but those challenges to the age restrictions were also unpreserved. Indeed, most of his arguments are also unpreserved.
Counsel, lower the microphone.
I'm sorry. Including those related to the MRTA and the court's decision to deny youthful offender treatment. Regarding the search itself, the body cam footage shows, just make sure the record is clear, that when he's asked for names, he provides 3 different names. And it's important to look at the court's credibility determination. If this court is to look at this despite this valid waiver, the video demonstrates that the court's credibility determination was due, there's due deference accorded to that. He provided 3 different names, he couldn't provide documentation, and the law at the time was such that it was sufficient, as this court has held, that it was sufficient to constitute probable cause to search the car and all of its occupants.
Oh, your friend just stated that he could have been given a ticket, a summons.
Well, as this court has held, and as the Second Department also noted in a case addressing MRTA, that the presence of marijuana caused the encounter to go beyond locating the driver to move the car. That was the language that the court used, and again, this court has held that the law was such that it was sufficient to constitute probable cause to search the car and all of its occupants. And then just going to the video, we certainly agree, as is true, that the video does not show his left hand. It's out of frame. Yet his actions, and this is key, as I believe Your Honor recognized, his actions are consistent with reaching towards his waist. He pushes his hip up against the car, and you hear the officer say, "Get off the car," while he appears to be leaning into it, which again goes to show these are all things that the court took into account in making the credibility determination, which is due deference. And if there are no further questions, I ask you to affirm. Thank you.
A few things I'd like to respond to. So first, the idea that Mr. Wilson is leaning into the car.
Again, is this not foreclosed by the fact that there was a valid waiver?
No, and in the waiver.
So
in
why
this
was
case-
this waiver not valid?
So, Your Honor, very briefly, Mr. Wilson's youth and complete lack of experience required the court to take special care in ensuring that he understood.
Have we held that?
Well, Your Honor,
Because I don't remember, really, there's case law that says that we look to quote-unquote lack of experience in viewing the waiver?
yes, when a person.
And so someone who has 51 convictions, we would just automatically state that they understood the
No,
waiver?
certainly not. This is just a factor that the courts take.
But
into
why in
account.
this instance was the waiver not valid? He went over it with his attorney. There's a written waiver as well. He did not express any reticence or the fact that he did not understand the waiver, right?
So none of that is a replacement, of course, for the court's colloquy. And in this case.
What was wrong with the court's colloquy?
So in this case, what's wrong with the colloquy is that the judge had Mr. Wilson admit guilt, be allocated
And
to
we
the
have
facts.
held that better practice is to not do that, but unlike the second department, which has now come around to us, it's been stated that that does not mean that the waiver is invalid.
He also signed the waiver form and
again,
delivered it to
we've
the court.
said
So
again, better
our-
practice.
Our point is that these factors taken together with his age and experience required the court to take extra care. And if
Even
Your Honor,
when he's represented by counsel and specifically states that he's discussed this with his counsel.
yes, because it is the court's responsibility to ensure that the record reflects his complete understanding of the significance of the waiver, which I'll also add was bookended by the trial rights on both sides, which led to the conclusion that, all of these were part and parcel. He had already agreed to waive the trial.
Was there a written waiver?
There was a written waiver that he signed
Signed
and
be-
delivered to the court before the court.
And I think that the
explained.
court not asked whether or not he had read the waiver over before signing it and discussed it with his attorney?
Yes, Your Honor. The court doesn't actually clarify that he understands the difference, but just because the red light is on, there were one or
The
two.
red light is on, so have a wonderful evening. Thank you so very much for coming.